people, the finances will take care of themselves. Every morning when I get up and I look in the mirror, I say to myself, today you're going to help some people.
I believe in Lloyd's mission. Lloyd's mission from the very beginning was serving families who needed to protect the resources and the relationships that were important to them. We've served over 30,000 families. So when people ask me why I'm here, I truly believe in the future impact that this firm can make.
It's really important when a client comes in that they don't feel like we're trying to shove them out the door, that it's a long-term relationship.
It's estate planning, but it's personal. And we're able to minister to that person and give them counsel and give them guidance and let them know they're not alone.
When we first walked in the door here, we just felt so at ease. They greeted us really in a wonderful, welcoming way.
We just had a much more positive experience than we have had elsewhere.
One of the things that we are known for is the fact that we have always put clients and their needs first. So service is extremely important to us.
As I was getting older, clients were looking at me and saying, hey, your hair's getting gray, I think you're going to retire. And I've looked for years for a company that would service clients in the same manner that I felt that I was serving my clients. And I finally found Copenbarger.
I've learned over the years that you do business with people you like and you trust, whether it's the gardener you're hiring or it's your surgeon and certainly an attorney. And what we found when we walked through the door was that pretty much immediately we loved the people here. That's why we chose Copenbarger.
Without our team of people, we're nothing. We have the best attorneys you can ask for, the greatest education and credentials, but without that team of people, we're not anything.
So not only are you servicing the client, the fact that everyone cares about each other unites us as one group, and it's pretty exciting to be on a team like this.
The Copenbarger firm is an outstanding firm. They are very generous, they are the most kind people, and they have done an outstanding job for my husband and I.
It was some 20 years ago, we made an appointment and we came to the office, and that's when we met Larry Copenbarger. He was an outstanding man.
We have become a family over the years.
I was really taken by his hospitality, his warmness, and that's how we became friends.
We're keeping that in mind when we're bringing new staff on board. They recognize that in order of priority, it's serving first. It's not just about their technical skill, it's really about making sure that they're a good fit culturally, and that's what's ultimately going to lead to a successful transition of Lloyd's legacy.
Someday I'm not going to be here anymore, but the people who have relied on our representation will be. And I know the people that are the clients of Copenbarger will be taken care of in the future just as well by the other attorneys.
When you hear it from our clients, they feel like they're cared for here, and I think to come in and want to change that, I came here because I want to care for them and I want to keep this legacy going.
It gives you a great sense of satisfaction that what you're providing to your client cannot be surpassed. Maybe equal by some law firms, but definitely not surpassed.
I'm very, very confident in the work that they do here, and my experience has been tremendous.
I believe sincerely when I look at the future possibilities of this firm that we can impact thousands of families, just like we have in the last 40 years.
Every night when I go home and I look in that same mirror, I can say to myself, you had an impact in some people's lives today that will make their lives better. Now, how does it get any better than that in life?
Good morning. All right, can you guys all hear okay? All you good? Okay, perfect. Well, thank you guys for being here. My name is Victoria. For those of you who don't know me already, I'm one of the estate planning attorneys with Copenbarger. We're going to go through a decent amount of information in a relatively short amount of time. So the handouts that you have in front of you, we very much encourage that you take notes, especially if you have questions throughout this. Because if you haven't been to see us this year already, you actually get a free consultation as a result of attending. So we often find that people who bring those in with the questions, it can really help to flag what was a concern that we brought up, what needs to be addressed for you specifically. So let me start though, for especially those either who don't know us or haven't seen us in a little bit, let me start by introducing especially some of our newer attorneys. So let me go first and say, if you don't know who we are, Lloyd Copenbarger is our founder. You got to see him in the video. He has been doing this for over 40 years and he's built quite a practice really focused on ensuring that people are protected and that things are kept out of court. We also have our attorney, James Kosarev, who's here today, who will be going through the estate administration and litigation side of things. The biggest thing we focus on the estate planning side is how to avoid court. But unfortunately, that's not always possible, whether because people want to fight or because something wasn't done that needed to be done ahead of time. We also have our business and tax department, so that's headed by Sunny Boren. She will not be here today, but if you have any questions on an LLC, a business, a rental property, just taxes in general, we're still able to help you in-house. One of the newest additions to our estate administration department is Mark O'Brien, so he joined us just about a year ago now and has been doing absolutely fantastically. He helps us ensure that our clients and their families are taken care of, again, especially after somebody has passed away. Elaine Alston recently joined us. She has been practicing litigation for quite a few decades now and is fantastic. Again, we frankly don't want you or your family to have to need her, but if you do, she is someone who advocates tirelessly for her clients and ensures that she represents them to the absolute best of her capabilities. Now, as attorneys, though, we could not do what we do without our staff. So our staff is the reason that we have been able to help so many people for so many years and in such an efficient manner. One of the big things we want to make sure, especially if there are emergent situations, is you get an answer. One of the things that we hate to hear from people who have worked with other firms is, I can't get a hold of my attorney. I haven't heard from them in a year, 10 years, 20 years. I haven't heard from them since I set the documents up. That should not be your experience with Copenbarger, and if for anybody it ever has been, please come and talk to us directly so that we can get that addressed. We also have offices all over the state. One of the big things to highlight is that our San Jose office has moved. So if you did not get an email with that, we have a map outside that shows where we have now moved to. So we moved because it's a good problem to have. We frankly outgrew the office location that we were at. I know many of you have come to know that one, loved the view that we had of all the planes there, but again, good problem is we needed to expand because our office up here has grown. But if you have any questions, if you do set up an appointment, again, make sure you don't go to the airport location, you know to go to the new one. So what are we going to cover today? So we are again going through a decent amount of information. We will establish foundation information. That way, if you don't have an estate plan, if this is the start of the journey, so to speak, you'll get a lot of those basic information pieces that you need. We're also going to dive into why do you need to keep coming to these seminars? Why do you need to keep working with your attorney? Estate planning is not a stagnant point in time. It is an evolving thing that works with your life. And so when your estate plan is established, it may carry on just fine for years to come, but it also may need to be updated periodically, and in some cases quite frequently, if life keeps doing these changes for you. So let's get started with your foundations. So first and foremost, when we're talking about estate planning, this is not just one document. It is a comprehensive set of documents that we are looking at doing. When we're talking again about this, if you ever talk to an estate planning attorney and they say you just need a trust, you just need a healthcare, unfortunately they are leaving something out from a protection standpoint that can leave you, your family, or your assets extremely vulnerable. So it is very important that when you are looking at having an estate plan set up, you actually have a set of documents, not just one. If you're a Copenbarger client and you have a trust, you should have all of these documents. But if you don't know if you do, come and ask us. We're happy to make sure that you do and make sure those protections are in place. But the first document that every single person over the age of 18 needs, and needs to have done since 2004, is a healthcare directive. If you have done your healthcare directive, but it was before 2004, it is actually no longer valid. So it is extremely important to make sure that that is kept up to date. The reason this one is so important is as soon as you turned 18, nobody had an automatic right to make your medical decisions anymore. That means your parents didn't. If you're older and you have your own kids, they have no right. You can't make decisions for those children. Your spouse doesn't even have an automatic right. So if you are rushed into the hospital and you can't verbally tell the doctor, I want my spouse to make my decisions, I want this person to do so, it has to be in writing. Otherwise, legally, the doctor can't tell anybody what room you're in, and they sure as heck can't tell you any of the information that goes into the HIPAA compliance. Now, there are some doctors and nurses who will play with this rule a little bit to make sure you have some kind of an advocate. But if any doctor has been sued under a privacy violation, they do not play with this at all, because it is an extremely expensive violation at that point for them. So to have this in place ensures you remain protected with an advocate. It also, though, takes a lot of the weight off of the person who's in charge of making those decisions. I can speak very personally from this, and I'm sure a few of you who have attended these have heard these stories. But when my grandma passed away, right before we got to that point, we had to make the choice about life support. One of the questions addressed in the healthcare directive was, would she want life support if she had a condition where she would no longer recover? She had said, no, do not keep me on life support. She was Christian, she wanted to go to heaven if there was no longer any hope. So it's a devastating decision to make, but it was an easy decision. I had no guilt, I had no question, I knew it was essentially making sure her wishes were carried out regardless of anything else going on. So being able to frankly take that weight off of the person or people who have to make that choice is one of the best gifts you can give them, as strange as that may sound, given the circumstances. So if you do have a health care but you haven't gone through or it doesn't even address those questions, again, come and see us, because ours absolutely do. The next document is actually a new document with Copenbarger. It is a psychiatric healthcare directive. One of the things that we have actually very recently found is for mental health facilities in particular, even though our healthcare directive does address some amount of mental health components, they are not accepting them, and they are actually telling people who are named in the health cares, you have no authority anyways. So we had a nightmare situation where the parents had basically no access to their adult daughter. They were told nothing. They knew she was in a facility, but the facility also wouldn't release her to them unless they had this document. So it was a nightmare. If you know anybody who is either already diagnosed with some kind of mental health disorder, if that is a concern, if this is something you want more information on, please come and talk to us. Because again, these are situations where you are extremely vulnerable, and the worst thing to be told is you can't help the loved one that's in there extremely vulnerable. And in reverse, their daughter then had nobody who could advocate for her at that point. So again, any questions on this one, do come and talk to us. The next document that everybody needs is a durable or financial power of attorney. This is again dealing with incapacity. For some reason, you are in a state where you can no longer manage your own finances. This can be temporarily, or it can be permanent. With temporary, it's extremely helpful to have because it's a quick blip in time, but you need somebody to keep making sure bills are paid, things are rolling until you can get back to it. If you are permanently incapacitated, you have to have this in place because otherwise people are either having to pay out of pocket to take care of you, they're having to go to court to ask the court to allow you access to the person's resources. It can be a nightmare not to have this document. If, though, you have a financial power of attorney that was not done in the last 5 years, you need to come in now. Especially in light of COVID, banks are really cracking down on financial fraud and elder abuse. And what that has meant is one of the ramifications is they're not accepting this if it is older than 5 years old. That was not a law change, that was a policy change, essentially for financial institutions. But it has caused absolute nightmare scenarios where people are not updating these documents, trying to use old ones, and being told you can't. Again, this is in a position where you can no longer advocate or appoint somebody because, again, you're incapacitated. So it is very important to make sure you have this document done ahead of time and that it is kept up to date. The other thing is you're giving somebody in this document access to your finances. You're allowing them to pay bills for you. Make sure you review this document to ensure that whoever is named is somebody you still trust. Again, we have had those nightmare scenarios where somebody named even a child 20 years ago and the relationship has fallen apart, and in that time that person still has the legal right to your money if they went and tried to access it to pay bills and take care of you, in theory, but it doesn't always then shake out that way again if the relationship has changed. So really make sure, again, when you're giving somebody that much access, it truly is somebody that you trust and who you believe will take care of you, not themselves. The next big issue, though, again, of not having a healthcare directive or a financial power of attorney and not having ones that are up to date is that is where we may need to go to court and then ask the court to appoint who's going to take care of you and who's going to take care of the finances. Those two documents answer those questions, but without those documents, we need to ask the court to make sure that somebody has the legal authority. Because good news is, people can't just walk in off the street and access your money. Bad news is, though, if it's somebody who needs to advocate for you and they don't have the permission and power, again, the court has to grant them that. Conservatorships, frankly, anything dealing with court, they are time-consuming and they are expensive because you now need an attorney to walk in with you and continue to go to hearings to get you the powers that those two documents would have addressed. So, hopefully I'm hammering it home. If you don't have those, if they're not up to date, come and talk to us now. The next question we get is, do I need a will or do I need a trust? So with wills in particular, and these are what I would call a standalone will. This is where you do not have a trust. You would qualify for a will if you do not own real estate or have less than $184,000. If you do own a piece of property or have more than that $184,000, a will is not going to be enough to protect you. And the reason is, once again, the court. They have said with a will, if you do not qualify under those conditions, that you have not properly answered the questions that they say need to be answered, and as a result, after you pass away, your estate winds up in what is called probate. Probate is there for the court to walk in and essentially answer the questions that they said your will did not. So it answers, did you owe any money? So do you have mortgages? Do you have car payments? Do you have things that need to be paid back? Does anyone owe you money? That's generally less common, but it is not uncommon. It's you loaned your kid money and they actually legally owe that back to the estate. It could be you loaned a friend money to start a business. That can be legally owed back to the estate. All of that gets collected. And then ultimately, where does that money go? The court has a lot of say in what actually then happens with those finances, which in some cases would be exactly what you would have wanted, but in a lot of cases it is not, because not all of our families are created equal is what I will say. And by that I mean, you may have two kids, doesn't mean both kids should be inheriting in the same way. You might have grandkids, their parents may have, God forbid, passed away. Now grandkids are inheriting and they're minors. There may be different things you would have wanted set up for them. There's a variety of different reasons that leaving the control in the court's hands is not a good idea. And David, you can jump 2 slides for me. One more. Perfect. So the other issue with probate is not just that the control is in their hands, which absolutely impacts the timing. We have found the average probate takes anywhere from 2 to 5 years. Even in the simplest of circumstances, it also costs a frightening amount. So you can imagine, if let's say you owed a mortgage, your home is worth $1 million, your equity is $100,000. The court's going to say, okay, that mortgage now may need to be paid in full, the house may need to be sold, and you pay that loan back, but we also get to put a percentage for a probate fee on the entire gross value of the estate. Not the equity you had, but the full $1 million of that home. And that fee is somewhere generally between 5 to 7%. So now you've got to pay your mortgage back. Now you have to pay your attorneys. You have probate costs. There's a lot that comes into it and absolutely eats down your estate and keeps it then from the people that would have otherwise inherited significantly more in many cases. Again, if you can avoid court, do it. Now the next slide that you'll see in your handout, this one just goes through a quick evaluation of what the approximate probate cost would be on a home with a median value of $1.4 million. If you are curious about what your estate would be if it went through probate, on our website, just Copenbarger.com, we have a probate calculator where you can put in your information, just a rough number, and it'll spit out what probate could cost you or your family specifically. Most of the time, especially for those who own a home in San Jose, the number is not dissimilar to what is on this slide, and it is a staggering number. What I can absolutely tell you is estate planning to set it up should not and is not cheap to have a good estate plan in place, but it is a heck of a lot better than having to pay that value just out the gate, right off the top, without any say in what happens when you're gone. So, what is the good news here? The good news is that you can absolutely avoid probate. And again, everything that we do on the estate planning side is designed to help you and your family do just that. So how we do that is by using a living trust. A trust is a document that essentially says to the court, I have answered all of your questions. I have gone through and said ahead of time who's going to manage things if I no longer can. It goes through and says, where are things going to go? It says, does a house have to be sold? Can somebody assume the mortgage? It goes through and answers all of those questions. So you're taking that control back, even if you're no longer here. Next one, David. The other thing is for the beneficiaries, you have significantly more say in how they inherit. So for a lot of people, there's concern about what happens if my child is married and gets a divorce? What happens to their inheritance if I'm gone? There could be concern about, I may love my child, but they're not maybe the most financially savvy. It could be, I have minor children. Just because they're even 18 doesn't necessarily indicate maturity. Maturity can be a very different conversation than legal adulthood. For some people, maturity may never set in even. So there's a lot of different things that you can do, again, in your trust, that you can't do if it's in court. The other piece that's a huge part of your trust is it allows for tax planning. So on the next slide, there's a couple of different benefits. Avoiding probate is one. Making sure your privacy is protected, which includes avoiding probate, is two. But unfortunately, tax planning is something, and I say unfortunately because it does apply to everybody, it is something that needs to be addressed. Whether we like it or not, taxes apply to all of us. And often, especially in our lovely state of California, there are significant taxes that can apply to us. One of the things with your trust is that it allows you to reduce or eliminate unnecessary taxes. So we will never say you shouldn't pay your taxes that are legally required. Pay your taxes. But why should you pay any more than is, again, legally necessary? There are a lot of different tax planning strategies for property taxes, estate taxes, capital gains taxes, things that can be done to ensure that either you, during your life, or your beneficiaries once you're gone, aren't paying those unnecessary taxes. So we're actually going to talk quite a bit about that in the later sections. Now, the next document, though, that you do need, even if you have a trust, is what is called a pour-over will. So even though you have a trust, you should also have a will. But this is different than that first will we talked about. This is not a standalone will. This is what I would call a safety net will. Essentially, what happens when you set up a trust is we will instruct you that there are certain assets that need to go into that trust, actually take title under the trust name. Generally, that is real property, checking accounts, savings accounts, and non-retirement investment accounts. Those are, again, in most cases, the assets we're instructing our clients that those will need to go in the name of the trust. If, for example, you have a bank account, you open it 10 years after you had set up your trust, you forget to put it in the trust name, for some reason you've sold a house, there's a lot of money going into that account. You've got $200,000 sitting there when you pass away and it was never protected in the trust. Ordinarily, that is still an asset that would actually be subject to a full probate. But we have created this will to tell the court, no, you don't get to have it go through a full probate. You need to give it back to the trust. That way your trust ultimately, again, has the control and your wishes are the ones carried out, not the court's. So this is not ideal. If you have asset questions and you don't know if they've been properly titled, absolutely come and talk to us. Because while this helps, it is still better to completely avoid the necessity of court, even with this being in place. But again, the good news is if life happens, if things slip through the cracks, you still should and do, if you're a Copenbarger client, have this protection in place. Yes?
I just
clarify. So checking accounts and non-retirement accounts should be in the trust. And savings, yes. Yep, so non-retirement, I really want to stress the non part of that. You should, if you're working with an advisor, they should not allow you to put retirement accounts into the trust. But unfortunately, what the government IRS has said is if you change the owner on a retirement account, which includes putting it in a trust, they'll tax the whole thing. So you don't put retirement in there. I really want to emphasize that. Yes?
I'm not asking you how much Copenbarger charges for attorney fees, but what's the general attorney fees per hour that's on the market today?
So it can really range, frankly. The attorney fees for estate planning, you can find people who, and we do flat fee on the estate planning side, you can find people who say they can get you a trust for a couple $100. Run, if that is what you are told, because I guarantee you are not getting the proper protection. Generally speaking, it should be anywhere from $2,500 and up, depending on the complexity. Are you a single person? Do you have minor children? What do you actually need included? But if you get a fee of anything, frankly, less than that, I would be very reticent if it's a brand new set of documents. Okay? Any other quick questions? No? All right. So the next thing to talk about is your stuff. So when we're talking about estate planning, it doesn't just include the monetary value of your bank accounts and your homes or whatever else you have. It very much includes your stuff. The biggest fights that we see, unfortunately, are often over your things. The things that monetarily may have absolutely no value anymore, but that people will fight tooth and nail over. And literally, we have seen it destroy families, and it is heartbreaking. What's the positive of this? The good news is that in your Copenbarger Trust, one of the ways that we help to remove some of that fighting is you have the power to leave what is called a letter of instruction, or a memorandum. Basically, what that means is if you do think somebody will be emotionally attached to something, even if they don't think they will be, you can designate that item just by using a separate handwritten letter that says what it is, who it goes to, and you just sign and date it. You don't need us involved, you don't need a notary, you don't need a witness. You can do those anytime you want. But it can very much help to remove that fighting by having an item just designated to a person. There's a lot that can be said about this. The other piece is, from a legacy standpoint, do you have items that have historical family value? Do you have photos? If you have your pictures, please label them for people. I will say my grandma was fantastic at that for half of her photos. The earlier half, I have no clue who's in them. There's no date on them. We've tried to ask the still living family. There's almost no way we're going to be able to track who they are. I'm thankful the other half we do have, and that actually helped us answer some of those questions. But those are things you don't get back. Once the people are gone, once there's no longer a person still living to say, oh, that was Aunt so-and-so, you kind of just lose that information. And so if you have those, and I know we now have our phones and so things have changed, but any way that you can label who is in pictures, things of that nature can have a really profound impact also. But if you have any questions on your stuff and how to help ensure that those fights are avoided, please come and talk to us. Because again, as much as we think it's all about the money for a lot of people in the fights, it really comes down to things more often than not. Now, the next asset that I want to hit on is cryptocurrency. So, I'm going to hit this very quickly because I'm not diving in on the financial advising side and should you or should you not. But if you do have cryptocurrency, you probably are wondering, okay, what do I do with that? Well, it is actually still considered personal property, which means to the government, it's equivalent to a piece of furniture as far as what happens with it. But it is also, if you have cryptocurrency, probably in your head of, well, the only way that this transfers is with my code or my key or my chain or whatever you have that identifies that asset. For most cryptocurrency, the only way, are we still here? Okay. The only way to actually access that cryptocurrency is, again, with that specific set of numbers, letters, whatever it may be. So we very much encourage, not only for this asset, for your email accounts, for your iCloud that has all your photos, have a secure place that is, but that somebody else can access. Because if you don't have that, there is not a way to recover it at that point. I also again mentioned iCloud. Apple is, for better or for worse, extremely good about keeping your privacy, almost to a fault. If you do not have any kind of proof that you should be allowed to access that account, you will not be allowed to access that account, period, end of story. They don't play with privacy on that one. So if those are things that are important to you and you don't know where to list them, how to list them securely, again, do come and talk to us because this is becoming a bigger and bigger concern. All right, so there's your basics. So I know that just on that was a decent amount of information. I'm now going to transition to, especially those of you who do already have an estate plan, why it is so important to continue coming in for these seminars and for reviews. So we generally recommend that people come in every 3 to 5 years. The reason for that is not that you're changing it every 3 to 5 years, but it helps ensure that you know to come and see us in case something changes. Because again, as your life shifts, your estate plan very likely needs to as well. So what has changed? What are some of the triggers that may mean you should come in? Well, for a lot of our clients, one of the biggest points of change is that when they first set up their planning, they had minor children, but now they have adult children. And there is a lot of different changes that can happen when you have adult children. It can be that they're now responsible enough to actually make decisions if you no longer can. The inheritance that you had set up, the plan you had established, that likely needs to change if they're older now and hopefully mature, but again, not in all cases. Are the beneficiaries flat still the same? When you first set it up, did you have siblings? And now, unfortunately, they have passed away. And so you're looking at shifting who the money would go to. Did you name charities or your religious organization? And now your intent for charitable giving has shifted. How does that need to be adjusted? And are you planning to move? Or have you just moved into the state? If you're planning to move out of state, I want to reassure you that your Copenbarger trust is still valid in each of the states. If you have moved into the state, I encourage you that if you had a plan created outside, have us review it, because in a lot of cases they are still applicable here, but not in all cases. And depending on the state you moved from, there could be a lot of changes that are necessary. So, if you are planning to move though, come and see us before you do so. One of the big questions becomes, how are your assets going to shift? Are you buying a new house in this new state? What do you need to do then to make sure that that house is still protected in your existing trust? Are you closing and opening bank accounts? Again, how do you make sure that those are protected? All of these questions we help you answer ahead of time to frankly help the move be a little bit more seamless. Moving in general never goes completely according to plan, but we want to take out, especially on the legal side, any of that worry that we can. The other issue is, again, are the documents valid in the other states, or vice versa? Are they valid here? Again, in every state we've had clients move to, our documents are accepted. But, for example, we've had some clients move to Texas, and they have what is called a homestead exemption. There is language that we can then include in our documents that allows those people to still qualify for that exemption in Texas, even though they have a California trust. The nice thing is, with the type of law that we do on the estate planning side, we're still able to represent you and then establish those new rules and put things into the trust without you, generally speaking, needing to find a new attorney. So if you are planning to move, or if you know someone who has that was a Copenbarger client, you don't now have to go find a new person. The next question is, has anybody since you set up your trust gotten married, or, and you don't actually have to answer this, or on the other hand, gotten divorced? These are two of the biggest components where please come and see us. If you have gotten married, there is a lot of different components that go into ensuring you and that new spouse, especially if it's a blended family, that blended family are going to be properly protected and provided for. I'm going to work a little bit backwards here. With blended families, one of the things that we talk about is, do you actually want your spouse to receive anything? And I know that sounds funny in some ways, but you may have brought a sizable amount of assets at the point that you're getting remarried. You may have your own kids and you want your stuff to go to yours, theirs to go to theirs. The problem is if you get married and do not even mention that that person is your spouse and you are not providing for them intentionally, when you pass away, they legally have a right to some of your stuff. So, if you do not want that to happen, you need to make sure that is noted. On the other hand, what if you do get married and you do want your spouse to be included, whether it's a first marriage or it's again a second or third or whatever you're on? There's a lot of protection that can go in at that point as well. Married couples have a few different advantages, especially when it comes to tax law protection. And they have their own components with remarriage protection. So with a married couple, one of the questions we ask is, very bluntly, are you concerned that if you die first and your spouse remarries, that they would have the ability to change the entire trust and as a result potentially remove some of your beneficiaries? A lot of people say no. That's the good news, is they say no, we have the same goals, the same ideas, we love each other, I trust you, fantastic. Unfortunately, our job is to kind of poke at that love just a little bit and say, okay, you love each other today, but what happens if, God forbid, either you're younger and so there's still a lot of time that the person could remarry, or the person that they remarry doesn't have the best intentions and has a lot of influence over now a widowed person who may be older and more vulnerable? Do you trust that person? Forget trusting the person you're married to, but do you trust this new person? The question then the heads start to go, well, maybe not. And so unfortunately what we do see, and I'm sorry for the men in the room, men are more susceptible to changing to take care of a new spouse. Women, generally speaking, continue really prioritizing kids. And this is just historical, so again, I'm hoping I'm not offending anyone. But men in particular, again, when they remarry, do generally shift to taking care of that spouse. And so we have seen some catastrophic and heartbreaking situations where the person, and this is man or woman even, they come in after their spouse has passed, they have the full control to change the whole thing, and that new partner gets everything. The kids are completely eliminated, and it all goes to that new person that you would not have wanted your portion of the estate to go to. So one of the things that you can include is a protection that says, if I die first, you can do whatever you want with your half of the money, but you don't get to change my half of the money. You can use it to take care of you because I still love you and I want you provided for, but you cannot give it away. It has to go to who I've designated when you die. So that is a protection you can put in, again, if you're a married couple, and again, love your spouse, but maybe don't love the idea of who they could potentially remarry if you passed away. So that's a big piece. So if you've gotten married, if this isn't something you've considered or discussed, come and talk to us. On the other side of it is, what if you got divorced? Absolutely come and talk to us. We have talked to a lot of divorcees who have gone 5, 10, 15 years without ever touching their documents, and I'm glad they finally came to us, because the reality that we have to explain is that person, if they were your healthcare directive, legally, go to major medical decisions. Legally, if they're your financial power of attorney, they have access to your money. Well, you divorced them for a reason, typically. You probably don't still want them to be your advocate, if they would even advocate, and especially don't want them to be able to touch your finances. The other issue is, if they're in the trust as your beneficiary and you die first, again, they get to actually legally inherit from you. The divorce doesn't override that provision. So it is very important, if you have not updated it since getting a separation or divorce, come and talk to us to make sure your money's actually going to go wherever you would really want it to go at that point. Next is how to protect your beneficiaries, especially your children. So again, with kids, we're looking at two main issues of who to protect them from. One is from outside predators, one is from themselves. Again, you may love your kids with all your heart, I hope you do, but it doesn't necessarily mean that financially they are the most savvy. Let me start with outside predators. So one of the things that you can establish in your trust is called a lifetime protective trust. This is a trust that says, when my children receive their inheritance, rather than it going into their name as an individual, it goes into their name as a trustee of a trust that's established for them. And it protects that inheritance. It protects it from divorce, lawsuits, creditors, bankruptcy, and the IRS. So if they're going through a divorce, even in a community property state, which we live in, it means it cannot be taken away from them in that divorce proceeding. If the spouse outlives them, and we'll go back to remarriage, they get remarried, your child had children, it ensures that that money will stay going to your grandchildren. So it stays in your family line. If your child is in a horrific car accident, it's completely their fault, and insurance won't cover the full amount, their inheritance is still insulated and protected and can't be taken away in that circumstance either. And again, as I just briefly mentioned, it will ultimately pass down to your grandchildren if you have any, and it passes free of tax. So it's a multi-generational protection at that point. It also can protect the person from themselves. So, generally speaking, it goes into the child's name as their own trustee, and they manage it, they can buy and sell within it, they can spend it, they have control. But in some cases, again, that person maybe shouldn't be the one who can just go and spend the money. So you could actually set up a trustee who can manage that portion of the inheritance for the child directly. The advantage there is that that child can still be provided for, they can still have all the expenses paid, but they don't have then the access to just go and spend it willy-nilly if they're not responsible to do so. So if you have any questions on that, absolutely, again, come and see us. Now this next part I'm not going to go through in too much detail because it doesn't generally apply to the majority of who we're talking to in these seminars. But what I will say is there's a QR code on the bottom of that slide. If you do have further questions about what I'm about to go through, we have a webinar that will link you to that goes into significantly more information. What I'm talking about is special needs trust and special needs beneficiaries. One of the things we hear from people is, I can't leave my money to a special needs child because they're on government benefits, and if I leave them money, they'll lose those benefits. And that is true without protection. If you have protections in place, though, as example of a special needs plan and trust, you can still leave that child or that beneficiary inheritance without them losing those benefits. So if, again, you have any more questions on that, A, I encourage you to watch the webinar, but B, of course, come and talk to us and set up one of those consultations. People have a lot more options than they are often aware of. Now, your planning, though, may stretch even beyond what we just talked about. There is a lot that goes into estate planning. So, are you concerned about your animals? This is a big one for me, so I always emphasize it. I grew up with a horse, and so that's not an animal you can just hand off to anybody at any time. That was definitely an animal as I was growing up that my mom went, well, God forbid something happens to us, you don't just put her in the backyard, who actually can have her? They're also extremely expensive, unfortunately, and so not just anybody wants to take on that burden. So there's ways that you can plan for if you have an animal with higher care needs, if you're concerned about who would actually take them to ensure that they don't end up in a shelter or in a lot of cases even put down, you can then come and talk to us about pet planning. Do you have rental properties? Are you concerned about ensuring that your renters, if God forbid they get hurt on your property, can't just wipe out your entire estate? How to protect that? Come and talk to us. All of these advanced planning components we can address. And so if you have a question on it, I would much rather that you come and talk to us because in most cases we do have a way to plan and protect you. Now, I mentioned legacy a little bit when I was talking about your stuff. Legacy is the reason that this firm was founded. Lloyd very much believes that every single person has a legacy, and that that legacy matters and should absolutely be accounted for and protected, whatever that looks like. For some, again, it goes to those photos, making sure that those things are labeled. For a lot of people, especially when they're coming to talk to us, it's about protecting resources, making sure assets will be properly used, that they won't just be depleted by the government. For some, it's religion, values, morals, things of that nature. I'm not going to go into a ton of detail on this one, but if you have any questions on how to ensure that your legacy carries on, whatever that may look like, and you're not quite sure where to start with us. This is something we take very seriously. We work with a lot of other professionals in the different industries to make sure that these are things that are accounted for and protected, because again, this is something that a lot of people forget about in their day-to-day life. You're focused on what comes today and tomorrow, but what comes if you're no longer here? Going back to this stuff, one of the big things we hear from people is, my kids don't want anything. Well, that's typically true because you're sitting there right in front of them. Unfortunately, as soon as you you pass away, a lot of times that stuff becomes the embodiment of the loved one. And again, that goes back to not only how to keep the fighting out, but also how to make sure that that legacy carries on. One of the stories that I'm sure a few of you have already heard, I'm using my grandma again, is she had a dining room set that she constantly wanted my mother to take. And my mom hated this dining room set, not because it was a bad set, but because my mom, one of the first things she bought in her life when she finally got home was a dining room set that she really liked and she had picked out. My grandma kept hounding me on this. Get the dining room set. Do it. You need it. You should take it. And it was a whole contentious issue, frankly, between them. Well, thankfully, before my grandma passed, she finally explained to my mom, this was a dining set that had been handmade by my mom's, I believe it was great-great-grandfather in Italy and shipped over and had been in the family since. That kind of changed the perception of this dining room table. It went from this irritation that my grandma kept pushing to, frankly, a family historical item. And so what's now in my mom's little dining room area, my grandma's dining room set. And so there's things that you can do, again, not just to keep the fighting out, but from that legacy standpoint, those stories, those items. Again, I really do encourage you, write them down, tell the family. We've got our phones, you can now record a lot of things. It definitely makes an impression and it can then carry on. It's a story I now can laugh at and hopefully keep sharing because, again, there's family components that otherwise it would have just been an annoying dining room table that caused issues with my mother and grandma. Rather than the funny and heartwarming now story that I enjoy for what it became when we got to know the rest of the situation. All right, so that's life changes. Next up, let's talk about the law, the stuff that unfortunately affects us that we're not often as aware of. So, there's quite a few that have actually occurred in the last couple of years. The first one I want to talk about is Proposition 19. How many of you guys at this point have heard about Proposition 19? All right, we've been starting to hammer it home. Hopefully, you're maybe annoyed actually at this point how often you get to hear about this. But Prop 19 is a big issue as far as your properties go that are in California. The first thing, though, I want to say is the good part of Prop 19 is if you are planning to move within the state and you are over the age of 55, you actually can now move your property tax basis up to 3 times to a new home. Again, it has to be within the state of California, though. So that's the good news. The reality, though, is the bad part of it. A lot of people over the age of 55 that we have found either aren't moving, they're not moving to a new home, they may be doing retirement communities, assisted living, things of that nature, or they're saying, I want to sell my home and get out of California because it's just too expensive here. So the good part of it, unfortunately, has not really come to fruition. The bad part of it is really what we have seen, and that is that for inheritance purposes, pretty much every property that is inherited now within California gets reassessed when a beneficiary inherits it. There used to be more protection, especially when you were looking at rental properties and secondary properties that have been completely eradicated by this proposition. What it now says is, with one exception, all inherited properties will be reassessed, period. The only exception is your primary residence if it's going to a child, and if that child claims it as their residence and lives in it indefinitely. The indefinite part is a huge piece that they frankly did not tell anybody and was only discovered as people were starting to move and think they could turn the property into a rental and then were hit with property taxes unexpectedly. So what we have found is it is indefinite. As soon as that child, even if they lived in it for 10 years, if they turn it to a rental, it's getting reassessed. Now, this is really an issue if you have more than one child. If you have one child, they get to decide. It goes to them. If they want to own it and live in it, they can. If they want to rent it, they can. That's fine. But if you have more than one child and they're all receiving this property, how do we protect it? Because a lot of times what we have unfortunately found is, let's say you have 3 kids, you're transferring a property to all 3 children, and then one does decide, hey, I would like to own and live in it. And so, can I buy you 2 out? Can I give you cash or something else in exchange of that value? They say, sure, why not? And so the kids are buying each other out. the one owns and lives in it. And all of a sudden they're shocked when they get a property tax reassessment for 2/3 of the property taxes. The problem is it transferred to 3 kids and now became a child-to-child transfer, which does not have any exclusions. It has to be between parents and their children. So one of the things that we can put in your trust is what is called right of first refusal. The right of first refusal rule says if you have 3 kids, in your trust you can say, this child is most likely to want it, this is the child I think would take it, I'm going to give them the first right to buy out the other 2, but through my estate, so that it keeps the parent-to-child transfer in place. But this language has to be in there. It has to be allowed. Otherwise, again, the 3 kids will inherit it, and now there's an issue of buying each other out. So if you don't have that right of first refusal language, and you are concerned that this is a reality you and your kids at that point would be facing, again, come and talk to us so we can make sure that's in there. The other thing is if you plan to buy a property in California, please come and talk to us before you do so. Because if you establish an LLC ahead of time, and that LLC has cash or funds that can then purchase that property actually can avoid, regardless of the use that you have for it, it can then avoid property tax reassessment. But it has to be done before. If you already own the property, this is not something that can be done retroactively. So again, I cannot hammer that home enough. Come and talk to us if you are going to do that. The next change is Medi-Cal. So, yes?
Do most other states have a similar kind of law? It's like this?
Most other states, I believe, are actually still under more favorable inheritance, but that is such a state-by-state component, I couldn't tell you definitively. Yeah, there's going to be some that are stricter than we are that give you no options, and I'm confident there's some that our clients have moved to that are now more favorable. Yeah. All right, so Medi-Cal. This is something we talk about all the time, because whether it applies to you directly, a loved one, someone you know, Medi-Cal is one of the most misunderstood programs that you, at any time you've paid taxes, have paid into in one way, shape, or form. Medi-Cal historically was unattainable because they said if you owned a piece of property and had more than $2,000, you would never qualify for it. Medi-Cal is needed, it's used if you financially qualify and physically need it. It is not based on age, it is not based on any of those benchmarks, it's really a needs-based program. So again, most people still remember the $2,000. A couple of years ago, it went up to $130,000. It was a huge jump. They've actually now completely eliminated asset qualification, which has been shocking, frankly. What that has in theory meant is any asset you have, regardless of the value and what your estate is worth, if you physically needed Medi-Cal, you could now qualify. But what they've added in is an income qualification piece. So depending on your income, will actually impact whether you can qualify for this program or not. The reason we emphasize this is, unfortunately, especially in this area, the cost of long-term skilled nursing is absolutely astronomical. An average bill we see is anywhere from $15,000 to $25,000 per month when somebody is in long-term skilled nursing. So what we've heard from a lot of people is, I don't want to deal with Medi-Cal, we have our own resources. So we then ask the question, do you have enough resources for $15,000 to $25,000 per month? And most people say, yeah, no, because that's a pretty staggering amount. That's more than the majority of incomes per month than when you were at your prime working every day. So unfortunately, again, for a lot of people, it's not an attainable level of care without some sort of help. So if you are in the position where you think you are going to need Medi-Cal and that kind of protection. If you know somebody who is and they are under the impression they cannot qualify because they don't know these new rules, have them come and talk to us, because these changes have opened up the program for significantly more people. But the application phase of things is very complex. And so with the application, they're not looking to qualify you, they are looking to disqualify you. So please come and talk to us if you're going to go through that, because we have helped many, many people qualify both as clients and, myself included, have helped people qualify in their own personal lives. So again, any questions on that, come and see us. The next one to go through is the Secure Act. So this impacts your retirement accounts. So IRAs, 401ks, things of that nature. There are new rules surrounding your retirement accounts. Now, I am not going to get into the financial advising again side of that. We have an advisor who's going to be introduced here in just a moment who can go more into that. If you have questions, you can ask him directly. But it does impact your planning. So what the rule now says is that if you pass away and have one of those retirement accounts, the beneficiary who receives it has to withdraw the amount within 10 years of you passing. So it is no longer on their lifetime. They have a 10-year clock that starts the day you pass away. There's a few different issues. One is the tax component, the ramifications, how should you be planning then financially for those different accounts, both yourself, but then also in light of those beneficiary rules. But the other piece is, going back to those protective lifetime trusts, if you have those protective lifetime trusts and you want your retirement accounts to also receive that protection for those kids, we have to update the retirement section in your trust. If you have not seen us in the last 3 to 5 years, you do not have that protection in there. This is not applicable to everyone. It may be something that you come in, we talk about and say, nope, you're completely fine. But if this is a concern, we need to address it. Because if you have certain accounts now going through the trust, and it does not have this updated language, it can have catastrophic tax consequences worse even than that 10-year rule. So again, come and talk to us if you have any questions. Now, a lot of the section in the slides that we have, again, I'm not going to dive very much into because truly, we want you to work with qualified professionals who can help you directly figure out when you now need to take your minimum distributions. How much are those distributions? All of those components really go into the advising and even CPA side of things. But what you will see through these slides is there have been a lot of different changes to how long you can contribute, when do you need to start taking things out, what are the penalties, all of these different pieces. So that is where for Copenbarger, we're not just an estate planning resource, we're absolutely trying to help connect you to other resources that can help you to ensure that you have that proper planning through each phase of life. The next one is gift taxes. So, gift taxes are extremely misunderstood. With a gift tax, most people are under the impression that if they go over the annual gift exemption, they have to pay a tax on that amount. That is actually not true. So 2 things. One, you can now gift up to $18,000 per year per person. So that number has increased. The second thing is, if you go over that $18,000 per person, you don't actually have to pay a tax on the excess, you just have to tell the IRS. And then the IRS deducts it out of your lifetime exemption, which today is up at $13.61 million. So unless you are planning to give more than $13.61 million, which if you are, that is fantastic, frankly, you're extremely generous. But if you're not going to be in that probably very narrow group of people, you wouldn't actually pay a tax on those gifts. You again just tell the IRS and they subtract it out of your lifetime exemption. So in some cases, people are looking to help with car payments, they're looking to help with education for either children or grandchildren. There's different pieces where this applies.
You said the 18,000 has gone up. What has it gone up to?
It's now 18. Most people remember when it was 15,000. Yep. All right, so it has gone up. Again, unless you're going over 13.61, you should not be concerned about having to pay a tax on those monies. The next thing is making sure, as again, going back to our married couples, if you are concerned about the size of your estate, one of the things that we talk about are estate taxes, the tax that applies after you pass away. For some people, they do, especially if you're owning multiple homes in California, you could start encroaching on the estate tax exemption. Now, the exemption today is, again, $13.62 million. Most of us are not concerned, even with the home you may own in San Jose, you're still not concerned about encroaching on that number. But that number is going to move in 2026 and be cut almost in half. So that can all of a sudden have a profound impact on people, and it is very much wanting to emphasize it is a moving number. So it doesn't mean that it can't go below that. But for married couples, you have an advantage. You have what is called portability. What that means is if your spouse, God forbid, passed away this year under the $13.62 million, you can actually elect to use their unused portion for when you pass away. What that means is if when you pass, let's say it's 5 years later, and they've lowered the exemption to $1 million, you can have your $1 million protected, plus whatever your spouse did not use. But you do have to actually do something to add it to your estate. You have to, within 5 years, file that you are electing to add that to your portion of the estate. So that does bring us back to the estate administration department, that if you have lost a spouse or a loved one in general, absolutely, again, at that point, come and talk to us, because we want to make sure, even though 5 years seems like a long time, when you're grieving, when life is in the way, even 5 years can fly by before we realize it. The next two deal with your banks and your trust. So the first is the Corporate Transparency Act. If you have a business, this applies to you. If you're a business owner, if you have a beneficial interest in the business. I'm actually going to skip, just in the interest of time, I'm going to skip to what is required. So, again, if you own a business, you are affected by this act. But now it means, and what it is entailing is you have additional reporting requirements. Now, the good news is what they're asking you to report, generally speaking, the Secretary of State already has. It's not diving too much beyond that, but it is yet another entity that you need to report to. Otherwise, there are hefty penalties that get applied every day that you go beyond the deadline. So, if you have a business, if you're forming a business this year, please come and talk to us, because those penalties, again, they are every day. You do not want to then miss making sure that that is reported. So what they're requiring you to report is your legal name, your date of birth, where you or the business are located, and then a photo ID. Again, most of this the Secretary of State already has. A lot of this is very redundant and obnoxious, but you can very much be penalized for not having this stuff re-reported to the new entity. All right, the other one is the FDIC. So this deals with insurance limits when we're dealing with revocable and irrevocable trusts. This is only changing a little bit, but again, it is important to note. Starting April 1st, 2024, so we're right on top of it, you are only able to insure in your trust up to 5 beneficiaries at $250,000 apiece. So when you have a trust and you go and open a bank account, you have some amount of insurance that protects if that bank goes under. It used to be essentially an unlimited number of 250,000 of beneficiaries, but they are now capping it at 5. So if you have 10 beneficiaries, you have a lot of kids and grandkids named, it doesn't matter, you would still be capped at that 5. This, for a lot of people, is something you're not maybe day-to-day aware of. It may not be something applicable, but if you do have more questions on this, do come and talk to us. All right, so again, that was a lot to start you guys off on the estate planning side. I've been mentioning, though, that one of the big things is we work with other professionals, because estate planning is not going to be the start and stop of all the protections you may need. So we actually work with a group called Lifestyle Financial Services. How many of you have heard of or work with Lifestyle? Number of you, okay, perfect. So our firm was started by Lloyd Copenbarger. Lifestyle Financial was actually started by Laura Copenbarger, his wife. So they have been walking alongside our clients because they are pretty unique in how much they understand trust and are frankly willing to work with trust attorneys. I've talked to a lot of advisors who are very unwilling to work with trust attorneys for one reason or another. And it just throws roadblock after roadblock in how we can protect our clients. And so having a resource like Lifestyle is invaluable for us, and then as a result, making sure you all are protected. But it goes beyond that. It's, again, your legacy. You're making sure that you're taken care of during life. Your families are taken care of. What do you want that to look like? So who we're bringing up now is actually my husband, for those of you who who don't know. So Zachary joined Lifestyle Financial a couple of years ago, and he and now Laura and Lloyd's grandson Charles are running Lifestyle. So I'm now going to turn it over to him so that he can sell himself to you guys and answer any questions that you have. All right?
Thank you.
So big round of applause, and a big round of applause for my wife, Victoria. I'm privileged of having full non-disclosure because I live as an attorney, so anything I say, I am not liable for. But I am only saying that, it's not written, so we're good. So you can call me Zach. In this suit, you can also call me Clark Kent, I've been told. But please feel free to see me when we take an intermission. Some of you know me. I recognize a lot of other faces in the crowd. Some of you guys don't know me. Always have to make a new friend. And I believe I'm up here to sell myself. So why do I want to say that? Well, at Lifestyle Financial and anything that you do in the financial space, I am trying to communicate what we do that show of hands. Anybody ever heard of Charles Schwab, Fidelity, E-Trade, TD Ameritrade, insert free trading platform here? I am in favor of those because it allows an access to information that provides everybody a chance to do some reading. These classes are not just for show. I need them to read or stare at screens. I read a lot during the day, and usually too late on my phone until Victoria tells me to go to bed. So I encourage people, come to us with questions, because while we are trying to validate and earn your trust, which is the most important thing in finances, we need to demonstrate that we are more than just page one at Charles Schwab. And every advisor should do that, no matter who you ask for. There's a great company that gives a great referral source to Copenbarger. It's called LegalZoom.com. Perhaps you've heard of it, or you've had to be referred to Copenbarger because something wrong was done there. Copenbarger goes deeper, and they're able to comprehensively help you. And that's what we try to do on the finance side. They make the estate plan. They make 4 walls of a very good legal document. Our job is to make the money in there, to be one, grow, but also to encompass and succeed in doing what you want these funds to do. So, what does Lifestyle Financial do? As Victoria said, we work in finances, cover all forms of investments. If you can put money in it, we talk about it. Financial planning and financial advising. Those are usually synonymous words. There's overlap. But at the end of the day, what we're trying to do is look at everybody in the room. You all have a specific, or a couple will have a family or a household dynamic. And our job is to take the universe of investing, which is kind of big, and simplify it to specifically achieve your goals. There is no such thing as one size fits all. Some investments may overlap. Many plans can be similar, but just as a rhyming scheme, which I know to say things can rhyme, they're different, especially throughout the course of time. So, quick show of some of the things that we talk about. There are a lot more that we talk about because we also try to apply this to everyday life. Say in a hypothetical, you have a child who's trying to buy a house, or a child who had a bad investment, and you're trying to help them bridge a period of time when they're struggling difficulties in their finances. Or, show of hands, anybody ever hear of house poor in Silicon Valley? Yes. Okay, at least somebody's playing with me. I appreciate that, sir. So we are entering a phase, and I'm known for trying to bring all of what's going on to the present, but drawing from history. Because history, similar to what I said earlier, doesn't repeat itself, but it tends to rhyme a lot. So we're entering a phase where people are living longer. So it's not just you and your parents or you and your child. There are sometimes 4 or 5 generations that are trying to figure out the complexities of surviving or having the retirement accounts belonging to those who are no longer working, or kids who have to spend 57 years in school to get 17 letters on a business card to get a good starting paying job, but then they're probably still house poor and they have $600,000 in student loans. I'm not speaking as someone who used to go to law school, but I have a lot of friends who are lawyers. Case in point, you can ask my wife, and they have a lot of student loan debt. So it's a complex dynamic when dealing with money. And what we try to do is come up with these plans. So why do we go through all these steps? Well, this is our full-time job. And I like to say it's a contact sport without playing any physical sports. I'm more of a tennis player, if you were to ask me, and I grew up playing tennis, so I actually don't know what contact sports are. But in finance, contact sport is a good way to visualize investment planning, having the conversation, because you need to react or sometimes try to not predict. You can't ever predict what's going to happen the next day in the markets, but you can have an idea of what likely will or will not happen. And we'll get into a couple of current events in a few minutes, and I'll even do some interactions with you guys because I like to keep everybody on their toes while they're sitting down. Because the markets do not stay fixed. There's no such thing as a pause button. Everybody ever seem to notice that life just seems to keep on going no matter what you have going on in your day? The markets are the same way. Good times, bad times, it's all linear progression. It goes forward in time. I'm sure a show of hands, maybe plenty of people, if you ever heard of a small company called Enron, you probably want to avoid it like the plague. But during that time, easier said than done. So what our job is to take all of this information and funnel it. Reading is a big part of our day. Another interaction, show of hands, who knows who Warren Buffett is, or who's ever heard of Berkshire Hathaway? So Warren Buffett, or whenever they have their annual Berkshire Hathaway big conference in Omaha, Nebraska, it's Woodstock for capitalism. They call it Woodstock for capitalism because you have Warren Buffett and a bunch of very experienced investors, and 30,000 people go to a place called Omaha, Nebraska, not just for the Omaha steaks, although they are very good, to try to get some knowledge from someone who reads almost 12 hours a day in the market. And he has said his greatest value is that he spent a lot of his time reading. So that's what we do. We spend a lot of time reading. And in part we do it because maybe you guys don't want to do all the reading that we're doing, or so that we can be aware of certain events that are going on and try to put that into the planning or the investment strategies that are appropriate. And with that being said, let's talk about the markets, because everybody recently likes to talk about the markets, whatever is going on. There's always something new. Show of hands, who has ever heard of the word inflation? Okay, yeah. Another show of hands. Who knows that 2024 is a presidential election year? If you don't, it is, and I really hope you vote. Please do. But show of hands, how many people know that there are over 135 global elections that will dictate over 70% of the global equity environment on the planet this year? Case in point, I'll give you guys an example. In January, there's a small island called Taiwan. Probably you guys have heard of it, or maybe it's neighbor China, or us and wanting to be involved in that part of the world. They had a presidential election. We need to understand that, because what happens on this island that is probably a very fractionally the size of Los Angeles County will dictate global environments for the markets, not just in the US, but around the world. And so we have to stay on top of that. We're going to get many more elections, not just our own elections, throughout the rest of the year. That'll reshape the map of how leadership in parts of the world will have their government set up, and then that'll dictate how they think about their markets. Maybe some people want to be doing more trade or less trade. Maybe people want to change the value of their currency. We use the dollar or the euro in the Eurozone. All that interrelates together. Okay, there's a word on the screen that advisors really do not like to mention. It starts with an R, it's called recession. We had a recession in 2022. Now we are what's called entering into a new investment cycle. Another phrase I like to tell people is markets do not ring a bell at the top or the bottom. It just keeps on going. Okay. So the strategy is you have to weather these storms, and you have to be able to take into account what is happening. Every new investment cycle has themes that are driving what is going to go underneath, and then we're going to see it in stock prices or bond prices. Victoria mentioned CDs, so I'll talk about that for a minute. With all these FDIC insurance limits, we have a way of using that rule on the investment side and spreading our money over all the banks in the US up to the insurable limit to help spread millions of dollars that are fully FDIC insured. That's just one way of us keeping an understanding of what's happening in changes to legislation and while protecting your assets for your own plans. On the market side, and this is very appropriate because of where we live, who has heard of AI, ChatGPT, or anything of the sort? We are experiencing an innovation cycle, and that's a fancy way of saying the next wave of some sort of technological development that's going to spread into different sectors of the economy is starting now. If you're a fan of baseball, we're not even in the first inning. The batter is still in like the little batting box or batting circle. I don't really know. I don't play baseball, as I said, tennis player. But we haven't even started the game yet. So what we're trying to figure out is how is this going to impact the markets? Probably a couple people here, maybe more than a few, have heard of a company called NVIDIA lately. That's the first precursor or the preview. There are going to be many more players in this space. How they get impacted, what sector of the economy they're going to be in, has yet to unravel. This is just the start, or as I like to call it for clients, they've probably heard, the picks and shovels. Picks and shovels are how you go into a mine and then you get out the precious resources, then you go into some sort of manufacturing shop and you come out and you got a watch or a car. But you need picks and shovels to get started. Also, with everything that's going on, you're going to hear a lot of noise, and I'll end with this. The important thing to do is have a source that you can trust. As I said in the beginning, our job is to earn your trust and then maintain that trust. We don't just start and disappear for a long period of time and you never hear from us. It's context for what we want, whether it be we're annoying you with a newsletter or just giving you a call or you're calling us, we need to stay in contact. So throughout all of this, we sift through the noise and we try to provide the objectivity that's required for financial guidance and planning during this time. And with that, my time is up. Please come see me. I'm always happy to give a story, and thank you very much. Now I'm going to hand it over to Mr. David.
Hi, I'm David. I just want to introduce Brad. Brad is a great friend of the Copenbargers. We've been working with him for a long time. We trust him wholeheartedly. He's doing great work for the kingdom, and I'm pleased to announce Brad come up. Just one quick reminder, and you can still clap while I'm talking, because it's great. But anywhere where you have to rush through today, at the end of every single subject, there is a QR code. And every subject QR code will take you directly to a webinar that goes in great detail for each section. So if you feel like you're rushed, you still have a lot to access to great information. Brad, welcome.
Thank you. Appreciate that, David. How many of you at times felt like you were just really discouraged? You just want to throw in the towel. You see everything that's happening. Well, I just want you to know that the fact that my wife and I next month will be permanently moving to Costa Rica, in no way should you give this. That's a joke. That's a joke. So, no panic. Anyway, how do you get our case updates? Raise your hand. Okay, a number of you do. Excellent. Yeah, in your material, you'll see like just a sign-up sheet like this. If you guys can make sure you've got one in your packet. Does anyone not have one? Raise your hand. It's not in there? Oh, just that. So there weren't any of these? Okay. Well, there'll be on the table in the back or outside. They'll be made available. Now, for you techie people, you can always do the QR code. Or you can text PJI to 71541. I remember it this way. A 71-year-old man having lunch with a 54-year-old woman, and there's a 1-year-old in a high chair. It works. I just can't forget that. So you help me with a new one. But anyway, we at Pacific Justice Institute I founded it back in 1997, and at the time I was coordinating litigation in 14 Western states for an organization headquartered back east called Rutherford, defending religious freedom, parents' rights, sanctity of life. And then what happens? I get a call saying, Brad, we're shutting down the regional offices, but we want to give you a promotion back east, head up our Washington, D.C. Public Affairs Office. You'll be the media face for all of our cases, all our litigation, radio, television, and you'll testify before Congress, higher pay, larger staff, right in the nation's capital. Pretty nice, huh? So I thought, yes. I said yes, and then I had insomnia. And I couldn't sleep. Next night I couldn't sleep. Next night I couldn't sleep. And I thought, oh, shoot, I got to pray about this. And why was that my attitude? I'll tell you why. Because whenever I pray about something, I'm always usually convicted to go the hard way, requiring faith versus the easy way. So that's what happened, and sure enough, I had that conviction to stay here, where this is the Omaha Beach, if you will, of the fight for freedom and liberty in America today, as far as I'm concerned. It's here. So with boldness and courage, I said, yes, I will rise to the call. I will rise to the challenge on several conditions. So I have your free office space, free computer system, keep me on the radio stations for free. We have to be in the black in just 3 months. I'm never going to charge anyone at any time for any work I ever do. I thought it was very reasonable with the Lord on this one. And God came through on all of it, and it was really incredible. We now, fast forward, have not just one office with free office space. In California, we have 6 offices with free office space. In fact, we have offices in more than 30 more than 30 offices across the country, coast to coast, all of them free office space. And which is almost all free utilities as well. And so it's pretty exciting on the radio. We went from 2 stations interviewing me to now we have our own show. It's called the Dacus Report. It's on over 800 radio outlets across the country. We don't pay a penny for it. It is the best show in the world. I love the guy who does it. It's my show. But it's a good show. It really is. So anyway, then we have a commentary on over 1,000. Then we have a TV program called Brad Dacus Live on streaming, and then another one called Faith and Law. And we're having a huge impact. We have over 220 cases in active litigation right now as we speak. We are leading the charge across the country with the largest platform of offices than any other organization. And what makes us really unique is we work hard to make sure that everyone gets help. So we don't just cherry pick those beautiful high-profile cases. We want to make sure that no one's left on the side of the road. So if you ever have anyone or know of anyone needing assistance in any of these areas, I want you to please contact us at PJI. Some of the things we've been involved in real quick is, when they shut down the churches and the synagogues in California and other blue oppressive states, but then the freedom-loving states, they opened up. They opened up everyone. Okay, restaurants, okay, churches, synagogues, you can open up. California said, no. Restaurants, you can open up. Strip clubs, you can open up. Not that I knew of any myself, but anyway. Pot shops can open up. Everyone can open up, except churches and synagogues. So it really bothered me. I don't get angry over these things. I just sue. So that's what we did. In a long story short, we filed a very aggressive lawsuit, very calculated lawsuit. We waited for this disparity to be very self-evident. And then we took it all the way to the Supreme Court with a rapid fire emergency writ, which is very difficult, extremely difficult. They took it up, and in just 3 days, 3 days, great things happen in 3 days. Yes. Okay, Easter, for those of you who are still there. So, in just 3 days, the Supreme Court ruled 6-3, ordering Governor Gavin Newsom open up those churches and synagogues down. And he did. And it was a real huge victory. And it sent shockwaves to other oppressive states, like Oregon and Washington and New York. And it was a huge victory. And then we had a second wave of a lot of people losing their jobs. And we stepped up to the plate when others wouldn't. And we took these cases on all over the country with all our offices, helping hundreds of thousands of people of faith who lost their jobs because of their personal religious convictions not to take a very controversial, quote-unquote, vaccine. I think you know what I'm talking about. So we took that on, and we've helped hundreds of thousands keep their jobs. And those that lost their jobs, we're litigating. And we're holding them accountable. And we took on Amtrak, we prevailed, we got all those jobs back, about 1,000 people their jobs back. Ascension Health got their jobs back. And we're taking on Whirlpool, and then of course a lot of government entities, fire departments, people firing police officers who risk their neck for our freedom and our safety, and then they lose their job. Things like that. So we're making a lot of progress. Then we have another wave of what I call pronoun cases. So it's this wonderful family in a Christian Korean family up in Olympia, Washington, has a woman's Korean spa. Now, Korean spas, it's women only because you don't wear any clothes in a Korean spa. The man comes in, you know what happened? Hey, I feel like I'm a woman, I want to go in there. They said, absolutely not. The mothers and their teenage daughters are in there, absolutely not. So he leaves, and he calls the Washington Human Rights Commission. So the Washington Human Rights Commission, which is an oxymoron, it's like George Orwell's 1984, they go, and they really are the Oppressors Commission, and they go in and they sue to shut down this Korean woman's spa because they won't let a man expose himself and visually violate women and young girls. Sick. It's totally sick. There's no rational basis for this at all. We're aggressively litigating. We're already taking it up on appeal. We also have a lot of school teachers who we're going to bat for across the country who are saying, we're not going to lie to parents about their kids. And we're not going to affirm something that violates our conscience. We don't want to encourage confusion on any child, especially when the statistics show that child has a higher likelihood of dying before the age of 30 than a child who's fighting leukemia. I mean, so it puts that in perspective. That's where we're at with the study. So it's real important that we go to bat. So we're doing those all over the country, keeping people from losing their jobs because of their convictions, not to affirm something that violates their faith and conscience. And mind you, when I say this, I don't mean we want to belittle people who have gender identity dysphoria. It's a real mental condition. And these people need love and compassion and support, counseling, and often there's issues that need to be resolved. 1 in 5 have already come out and said they wish they hadn't. So there's a lot of issues like that we're dealing with as well. Religious asylum, we take those on for people from communist countries, radical Muslim countries, really making an impact. So we're handling a lot of different cases. Jewish students being persecuted on university campuses, we're going to represent every single one that needs representation. Always, all our work is without charge, because we've got to stand up for freedom and liberty for everyone. So there's a lot of cases we're handling, and I encourage you once again, I apologize that we didn't get these in your packets, because that's really important that you have that availability. So if you'd like to, if you make the extra effort to visit me in the break, and we have some over there sitting out, and we can pass them out or something, David, to make sure this happens, that everyone gets them full. Okay, great. I really appreciate that. Finally, let me just say this. You're at Pacific. This organization, Copenbarger, they handle our trusts. We're making some changes on it. I know lawyers all across the country who do this work. I would choose logically the best ones. They are the best, and with high integrity, high character. And that said, it's a great thing to protect your assets. It's a noble thing to do that properly. You're being responsible. Hats off to you for being here. But let me just say this. Those assets are not worth much if your kids don't have freedom. We are working hard and diligently to ensure that they have freedom and that their grandkids have freedom. If we can ever serve you in any way, please let us know. And I look forward to keeping you updated on our many, many cases from the crazy state of California and beyond. God bless you all. Thank you very much.
All right, I'm back. So we are going to wrap you in for a break. One of the things, though, to talk about before the break is our Access program. So how many of you are Access members? Okay, perfect. So I'm actually going to ask Chris. I'm completely throwing him off guard. He had no time to prepare for this, but a couple of things with the Access membership. First is, what is the existing program? So I'll cover that. But for our Access members, I'm going to have Chris allude to what is coming next. So first and foremost, for those who do not know what the Access program is, it's frankly right in the name. It helps give you more access to us as your attorneys. So for our Access members, they currently receive 2 hours of free attorney time, regardless of if they come to a seminar or not, which means if you have a simple question, if you need something after the consultation, you need just something easy or complicated, you can give us a call and then you're not charged for that. You and your referrals also get $300 off your planning. So for Access members, every Access year, if you do any change, you will receive currently $300 off those changes. Anyone you refer to us for first-time planning will also receive that $300 off. One of the most unused things, though, on your Access program is if you are physically unable to come to us, we are able to come to you free of charge. If you are an Access member and you, again, have not been able to come to us, or if this happens in the future, I very much encourage you to take advantage of that. It is something that, again, not many of our Access members do. Now, again, totally putting Chris on the spot. This is our CEO, actually. I'm going to have him allude a little bit to the upcoming Access changes. You're welcome.
Thank you. I'll find some way to get back at you for this. One other thing that I did want to mention that is also a very underutilized portion of the Access program is that 24-hour access to your documents, to your advanced healthcare directives. That allows you, if you're traveling, if you're visiting kids, grandkids, on vacation, away from home, whatever it is, and you go into a hospital or you go into a facility where you need that advanced healthcare directive or you need that power of attorney, you have access to that anywhere in the world that you have an internet connection. So that's a really underutilized portion of it. The reason Victoria is asking me to come up is because we're actually going to be enhancing the Access program. We're actually going to be adding a couple levels, and existing Access members are actually going to be having additional benefits added at no extra cost. Existing Access members are going to be grandfathered into the program, and so we'll be rolling that out within the next probably 6 months by the time we get it back up here. But we're going to be adding things. When we started the Access program many, many years ago, this firm was primarily just estate planning and a little bit of administration. Over the years, our practice has grown. Now we have business services, we have tax services, we have estate litigation, we have conservatorship, guardianship, probate, administration, and all of those are pretty equal sizing in terms of our estate planning side of the business. Well, the Access program currently only relates to and only has benefits as it relates to the estate planning side. So we're going to be improving the program, expanding the program to have benefits for all of the different service areas that we have as a firm. And again, existing members will be grandfathered into that program. So a lot of good things coming. If you have questions about it, please let us know. I'm happy to answer them. I'll be at the table in the foyer out there and happy to answer anything you have. Thanks.
Thank you. That was on the spot. So there we go. Thank you, Chris. And as he mentioned again, existing Access for that grandfather program. So if you have been considering signing up for Access, I would encourage you to really think about doing so now before that program shift so that you can get in again with being grandfathered in. All right, now we are at the time for a break. So a couple of things with that. One is, if you need to use the restroom, please do so. It's out to your left. If you are still hungry or you want to refresh on coffee, please feel free to help yourself to the remaining pastries and coffee. But again, as I mentioned, if you haven't seen us this year, you are entitled to a free consultation. All of you, though, can sign up for an appointment regardless of that. That is going to be back at the registration table. So where you checked in, you can now sign up for an appointment. If you're not quite ready for an appointment, you can either let us know that, we'll put you on a list, or on those green sheets we handed you at the very beginning, you can actually mark that you need an appointment, but you need us to call or email you. If you have any questions at the break, we'll be lingering around, so feel free to come up, and we'll see you back here. Can I get you 11:32. We'll see you back here in 15 minutes. We'll give you 10:50. Oh, and if you want a stress ball, so we have quite a few of these Copenbarger stress balls. If you have felt some stress, if you lovingly want to chuck a soft thing at somebody, you can grab one. Dale, my Lord, as David just did. Feel free to grab one of those. They're in the back. We'll see you back at 10:50. Thank you. Well, so the first part of the $300, that's just the one-time access to them. So you can use the 300 for change. And it's every year that you get access. It's a one-time access. Yep. Yeah. That's the first time that I didn't recognize it. No worries. You look more like a children. Well, thank you. You are like a Ethan. You look like a young baby. There you go. Thank you. Hey, more ready. A girl. Yep. She already have a name, I think. Oh, yes. Yes. Yeah, we're. I guess so.
Oh, yeah. I knew you were going to talk.
There you go. Well, yeah.
So, in your watch that. What's interesting, our review of updated
Yeah, really. Or sit that gentleman over there.
there's always something that's sticking out there. So far, so good. So far, so good. Nightmares from work. Ah, right. Hello, hello, hello. You're going to start in about 90 seconds. I'm going to hold my breath and see if I can do it for 90 seconds. I'm just kidding, I'm not going to do that. I mean, in the middle of days, yes. James, I won't even move, James. You can hear me. Go ahead. Go ahead. You get one throw. James had a ball, he's going to throw it, but I'm encouraging him to throw it. I don't think he can hit me. Come on, James. He can manage your trust like no one in the world, but throwing the ball, I'm not sure.
I might throw off my arm.
Yeah, we want to throw out his writing arm. He's got a signed document with that hand.
Yeah, orange.
All right. All right, well, while we're waiting for the next subject, I'm going to do a quick little plug here. So first of all, my name's David. I kind of do a lot of things with the law firm, whether it be the tech stuff, writing some material. My biggest focus is setting up church seminars. So if anybody has a church that you attend that you think our services would work well in communicating with that, you're welcome to come talk to me about that. I've got some business cards in the back. And these are basically the things that we do. We kind of partner with pastors and educate the flock and helping them protect the flock as well as our pastors. A lot of pastors in leadership, they have no shortage of ideas and visions for the future of the ministry, but they're kind of like short of funds, like everyone else is. So we work with pastors and leadership and how to raise capital for the kingdom, because that's what we do. So if you were interested in that at all, feel free to see me in the back. And with that said, I'm going to invite up Victoria, and she is going to take over the next section here.
She's tall.
All right. Now, normally she likes an applause when she walks up, but here you go.
All right, I'm back. You're getting to hear from me a lot today. So the next section that we're going to go into is more of the advanced planning stuff. So that's the things that are more specialized. This may not apply to everyone. It's a quick subset of the different planning that we do, but I can now speak after the break. It is things that do apply to certain people and are of concern. So I'm going to get started with what 3 we're covering today. So, how many of you have a firearm? Well, you may not want to tell me if you have a firearm. If you have a firearm, David says he does. We're going to talk about gun trusts. If you are interested in charitable giving and what that can look like as part of your estate, we're going to talk about that some more. And then your property. What planning can we do for that? So gun trusts, the reason that we're talking about these is for any of our audience members that are gun enthusiasts, you enjoy your guns, and even for those who may not. The commonality between those two groups is, in general, you want to make sure it's legal and safe. Those are a very common overlay between the two sides. Again, both between those who are very responsible gun owners and those who are concerned about gun ownership. One of the ways that we can help ensure that those two pieces are met is with a gun trust. If you are a resident of California and if you are a gun enthusiast, you likely know that California rules as far as guns go are not often favorable. They are more strict and they change or are threatened to be changed fairly frequently. So one of the concerns can be, what happens if I have beneficiaries in my trust and I just want them to receive the guns? That can be a problem if you don't have proper protection in place. What happens if the rules change and the gun that you are leaving that person will actually now make them a felon for owning that weapon? What happens if the rules change where that gun legally, period, cannot be owned? What happens if you do not have a registered firearm? It is a historic firearm. There's different issues that can come up where if you just leave it to a person without any additional guidance, without any additional provision that allows them to address those new laws and those shifts, can cause some serious problems. In today's world, certain misdemeanor people can still own guns. But again, what happens if that shifts? You really can set people up to accidentally violate the law in a way that is fairly harshly bad without even meaning to or realizing it. So if you, again, are a gun owner, and especially if you have a large quantity of guns, which a couple of our clients do, or you have those specialized guns that are more historic or are not under the traditional registration rules, absolutely come and talk to us, because truly this can end up being a nightmare scenario for the beneficiaries that we can 100% avoid. So it's also important, though, with a gun trust to seek legal counsel. Because again, this is not an area that you want to risk. This is not something that you want to be fast and loose with and go for the cheap option online. One of the things a lot of when we were researching even our own gun trust that we have found, most other states have very, very simple gun trusts because the rules are not as strict. Especially if you live somewhere like Texas, or if you get a Texas gun trust, it's a little bit different than living in California. So what they need from a gun trust standpoint is night and day different than what you would need in California. So trying to just find something online, trying to do a do-it-yourself method, unfortunately, again, can walk you and especially those beneficiaries into a problem if it is not done according to California rules. We did a webinar on gun trust, so again, that little QR code that should be in your handouts as well. If you have more questions, you want more information on this specifically, you can go to that. If you aren't maybe as tech savvy with the phone QR code piece, it is also on our YouTube channel, so you can also always just go and search that and find it. The next thing to talk about is charitable giving. So, for some people, their charitable giving is done during life and they don't want it to continue when they pass away. They say, I want it to go to my kids, and then they get to decide if or when charities will be included. For others, they do want the charitable giving to continue after they have passed. And this can be done in a variety of ways and different layers of ways and levels. Giving in general, what we have found is it does increase people's happiness. A lot of times when you're giving during life, it does make you happy in one way, shape, or form. But that actually carries on even for often the family when they know that you're supporting, especially those organizations that meant a lot to you and that your kids are aware of meant a lot to you. There's a lot of different ways so that you can give. You can give just through your revocable trust. You can say, in my trust, I want this amount or this percentage to go to this charity, and it just goes. For other people, though, they want to do more advanced planning protections. They actually want to leave larger assets that can include properties, that can include investment accounts. They have more advanced planning desires when it comes to that charitable giving. And so that's where we start to look at additional planning options. Now, one of the big things with charitable giving that is also an advantage is there's more money either left in your pocket if it's during your life or after you pass away. One of the things, especially if you have an estate that is larger, that can be a concern is going back to those death taxes I mentioned. What can the federal government tax your estate if you pass away with an estate that is larger than the exemption? If you are concerned about that, charitable giving is one of the ways to help reduce and a lot of times eliminate then that tax. Because what goes to charities gets reduced out of your taxable estate. The IRS doesn't get to have a portion of that. So, for most of our clients, if that's a concern, they would much rather it go to a charity then to the IRS. So if that again is something that you're concerned about and want addressed, we can definitely help. Now going into the advanced charity planning, the advanced charitable planning, that is where we start talking about what are called charitable trusts. These are trusts that are set up with the intent that you are leaving an asset to a charity. You are designating this thing to a charity. Now again, in most cases, this is used for larger assets. One of the reasons I mentioned property is we've had clients where they're setting up, they really don't want the property anymore, it's a rental, they're sick of managing it, they're debating selling it. So one of the things we talk about is, well, do you still want any kind of income from that asset? And they go, well, yeah, but if I sell it, it's gone. One of the things that they can do is set up a charitable trust to put that asset in. It can still then produce an income for them, but then when they pass, that asset just goes to charity. So rather than them having to sell it and get capital gains taxes, they can house it essentially where it still produces something. They can appoint someone else to even manage it, but ultimately it then transfers over to charity rather than just disappearing from their estate. So again, if this is a concern or something that really means a lot to you, it's something that you really want to touch on, I encourage you to come and talk with us. This a lot of times is where you work with our attorneys Sunny Boren and even Lloyd, because these are very much more advanced planning components. They involve different tax components. They go above and beyond a traditional revocable trust, but it is absolutely something that we can still assist with. Now, what about your real estate? So, who in here, if you're comfortable answering, owns a secondary piece of property, a rental property? Anyone in here? Okay, a couple people. Unfortunately, when you have a rental, you are increasing your liability risk because renters, God love them, are not always the most responsible people. And unfortunately, if they get hurt on your property, can actually look to sue you, because I'm going to put that bluntly. When you're looking at renters or anybody else on your property and that risk of litigation essentially is coming up, that liability risk is coming up, one of the things we encourage you to think about is an LLC. An LLC is essentially there to ensure that if a catastrophe occurs, it doesn't wipe out your entire estate. It keeps it locked to that LLC liability at that point, again, rather than extending to all of the things that you own. So that can have a huge advantage, again, when you're really dealing with renters. We've had people who own different condos or even apartment complexes, and the more renters you have, the more risk of liability that you have. So as much as that income is great, and as much as we're not encouraging you to get rid of those properties, we are very much encouraging you to look at making sure you are protected while taking advantage of having a rental income. So I know that that was relatively quick. James back there, I'm going to bring him up here. He gets to talk about the wonderful world of litigation and making sure that your legacy is defended. This is something that unfortunately has affected my family, where I have been in litigation for my grandmother's estate because I have a family that they fought during her life and they fight worse after she has passed away. And she named me as the trustee, so I get to deal with them. Love my family, but litigation is not something that I personally love on this side of things. But I am so thankful we have Elaine because she has been able to step up, and even though I am an attorney, I love having somebody to defend me where I don't have to think about the personal side. I can put that in her court, she takes the ball and runs, and is able to then show up. But it is something that, again, unfortunately does apply. You get to throw a ball at someone? Don't take the ball. I was going to chuck it at somebody. So at this point, I'm going to turn it over to James Kosaref. So he's the head of our estate administration department. And just, Zach, don't you dare. He's points in with the ball too. Take him away from all of you. With that being said, with administration, there is a component of court that comes into play. And so I'm going to turn it over now. Thank you.
Thank you. Thanks, Vicki. So the defending legacies is really all about a lawsuit. It really is. And it's what happens after you're gone. Or maybe you're still here, but you're incapacitated. Excuse me. My age is going to show. So it's really, a lawsuit in court. I mean, that's really what it comes down to. And sometimes it doesn't need to be there. And it's primarily when reasonable minds don't prevail. Okay?
Yeah.
And so that's basically what we're talking about. And so, how many here have kids? Most of you. Right? How many of you have parents? Or had parents at one time? Okay. All right. That's most of you too, because some of you didn't raise your hand in either of them. You guys must be clones, right? Okay. All right. So next one. So, usually, when your kids were young, they never fought, right? It was always the neighbor's kids, or your brother's kids, or your sister's kids. They're the ones who fought, right? But kids, they fight, and at the time they were young, whether they're 3, 4, 5, 6, 7, 10, 15, 45, 75, while you're living, who basically kept the family together? Yeah, parents, mom or dad. Mom or dad. So then mom or dad now passes away. Do the kids still disagree? Absolutely. But who at that point separates them? Right? Who separates them? And especially think about it from a standpoint of if that child of yours has a spouse. Look at now there are people chuckling. Okay, where you going there? Does that spouse influence your child? Absolutely they do. Just like you influenced ladies, you influenced your husband. So, but the idea behind that is if you're no longer here, right, to help solve those family disputes, how do they get resolved? And that's the court, right? The court of some nature like that. And so the parents were always the referee. After lifetime, the judge becomes the referee. And that's kind of the idea here, because the kids, they're still going to have their differences, and those differences actually may get larger or more difficult because of spouses and because of families and because of their own concerns and what's happening in their life and everything like that. So problems that lead up to that. Well, one problem that could lead up to it is just the sibling rivalry to begin with, right? For instance, I have 5 siblings. Parents had 6 kids. And I've been told, while my mom was alive, I've been told that the other 5 thought I was the favorite. I don't agree with that. but that's what my mother told me, right? And so I don't always believe what my mother says. But let's just think of that being the case, though. If that's the case, if that's what they think, and then all of a sudden I become trustee of mom and dad's trust, well, that in of itself can cause problems, right? It can. And it's not a matter of whether I could I'm the best one to do the job or the worst one to do the job. It's just a matter of just me being there could be a problem. Because I'm not the oldest. I'm 4 of 6. Right? And so I'm that middle one. I'm one of the middle ones. And so from that perspective, it's like, well, maybe the older one thought that they should be because they're the oldest. Right? And they're the ones who always live. In fact, isn't any firstborns here? A couple of them? All right, okay, I'm going to pick on you. Be prepared. So typically what happens with the firstborn is that, when they're the firstborn, and then there's a couple of kids after them. And once the firstborn gets to be a certain age, right, what happens? Well, mom and dad start saying, okay, we're going to go out and we're going to go do something. You watch the kids. Right? You become the designated babysitter without pay. Right? And so you start to have to mature a little quicker than the others. And so it's like, well, that was my job growing up. I need to maintain that, right? And so those are the things that come up. And so if that first one now, who's been in charge of everything, in their mind for all of this years, all of a sudden mom and dad pass away and they're not in charge anymore, there can be some issues there. So those are the kinds of things we're talking about. Documents, and so when we come into other things, though, that cause problems, maybe the document wasn't drafted correctly. Right? We have situations from time to time where it says, I want after I die, I want my estate to go to my descendants. Well, who are my descendants? Who are my descendants? Well, if I have kids, if I have grandkids, great-grandkids, it's all of them. Well, was that what I intended? So sometimes we're headed into court because they really didn't mean descendants, they meant my kids, but it's now going to 20 people rather than 3. Okay? And so we're headed into court for that reason. Incomplete documents. Well, how can the document become incomplete? Well, part of it could be an incomplete document is because things have changed. At one time, I had, I had all healthy children, but now one of them can't care for themselves, right? One of them's incapacitated now, but my documents don't dictate that. Or I have a situation where I know my family has some problems, and so I put it in the trust. And the family now thinks they're perfect, and they don't need it in trust. And so they're trying to break that. All of those things come up. So either incomplete, or drafted documents incomplete, or they just disagree with what your documents say. And they don't want what you put in force to go out. Out-of-date documents, again, that could be a matter of kids. I do have kids, I don't have kids, and now I do have kids, or a child of mine has passed away, and I intended it to go one way, but it's going a different way. So it all just kind of depends. It kind of depends. And of course, greedy children. None of yours. None of yours. But they're out there. Those greedy children. Part of it with the greed, though, see, for me, I think all of it stems from pride, right? And so from a perspective of that, even greed stems from pride because it's I deserve, right? I deserve. And so there may be some emotional things there. It could be that somebody can't transition from a mom or dad passing away. Right? And there's some problems there too. So they can't transition from that. And that would be, they're grieving or like I said before, because of sibling rivalry, and this one was the favorite, and I always felt like I was a black sheep or whatever the case may be, the idea or the sense of injustice, right? In all of this. Or look at, towards the end of mom and dad's life, I took care of them, and now I'm having to share everything equal with all these, people, and they didn't help out one bit. And again, that's not what your intent was, but in their mind, those are the things that they're thinking about, right? And so those can cause those types of problems. Who do we represent? Anyone who pays. Right? Trustees, beneficiaries, we're lawyers, right? So, But you can think of it this way: we were created to be lawyers by God. So there you go. You can't wait for you have to honor Him in what we do. So it's just when we do it wrong or poorly. All right. So trustees and fiduciaries, beneficiaries, we represent everybody because sometimes a beneficiary needs to be represented because the trustees are not doing what they're supposed to, right? So what when representing a trustee, why would we do that? I want it now. I want it now. Give it to me now. Mom and dad just died. Give it to me now. There are times where I'll get a phone call on, let's say, a Wednesday, and the trustee saying, "Yeah, I'm trustee. Mom, dad just died. We're getting together on Saturday and giving it all, taking care of it." Whoa, right? Whoa, just slow down, right? Pull back on those reins a little bit. Beneficiaries can be impatient, and the problem is, you'll see in a little bit, it's a administrative process, and that process takes time. It's not like a probate where it could take more time. Because I've been fond of saying, legal issues take time to resolve. But when you get the court involved, go. that's just the nature of that beast. And it's not necessarily bad because sometimes it's needed. Sometimes it's needed. It's not necessarily a bad thing, it's just needed. But beneficiaries can be impatient. They can also be unthankful, right? Because of course entitlement, it's all mine, it should be mine, I deserve it, and you shouldn't get any of it, right? And I always want more. I've never filed a lawsuit or filed any kind of action in court because someone wanted less. Never done it. I mean, maybe there's an attorney out there that did that, but I've never done it. So, and again, unresolved conflicts, right? The family members and that you don't, from my vantage point, that is probably the biggest issue of all things, is the kids somewhere, there's something in the back there that just brings it up forward when mom and dad passes away and it just can't be resolved. And so I've been given into this sibling of mine my entire life, letting them have their way, mom and dad letting them have their way, and doggone it, I'm not going to take it anymore. Right? And that's basically what happens. Can you hold that?
What you're saying? You think that you're going to outlive the problem.
Yeah.
And you're not.
That's true. You're not. Well, or you're just going to sweep it under the rug, and I'm going to pass away, and I'll be in glory, and let them deal with it, right? And so when we represent trustees, or when we're representing beneficiaries, why are we representing beneficiaries? Well, primarily, if you've been to any of these conferences over the last couple of years, and what I'm going to go into after this is just kind of a bullet list of things that the trustees need to do. And so it's essentially one of the things is the trustees just not doing their job. They're not doing what they're supposed to do, or they're being creative and deviating from what you've put down on paper. Right? And so that's usually what happens when we're representing beneficiaries. Also, the trustee may not be best positioned to carry out their duties, right? So my mom used to say of me, she said, James, I don't mind you handling the money. I just don't want you to make medical decisions for me. And why was that? Right? She was concerned that if there was an end-of-life decision, I would be making that decision fiscally. And maybe so, but I think that's kind of the case, right? And so it's like, well, all of us are not gifted with compassion. And some of us are. And so from that perspective, it's like she took, she would have the opinion that, okay, I'm not going to let you make some compassionate decision for me. And solid, logical, fiscal decisions you could make, right? But and if you ask other people in the office, yeah, you could pray for compassion for me if you want to pray. The trustee is just flat out stealing, right? Using the trust as their own personal bank account. And that's either when mom or dad are living or even after they pass away. My dad's in a situation right now, he's 90. He's in his 94th year. So he'll turn 94 in May. And one of the tasks in the next couple of weeks is to visit him down in the Royal Grande and put me on as a co-trustee. Right? Because he's at that point in competence where he's still rational, so he hasn't turned to irrational and to the point, right, where he's paranoid, right? Because that happens, and we've seen that in people we know, people we love, and so he's in that point right now where he's still acting rationally, he's making rational decisions, and so it's like, okay, let's put you on and make it easier for him. Right? But if I get in that position, I have access to all the accounts, all the money. Well, if I lack integrity, You know, and if all of a sudden I start needing some of that, my mind's needing it, right? Then I'll put it back later. Because I may not be doing it with malicious intent. I'm doing it intentionally if I do it, right? But I may not be doing it with malicious intent, but I'm doing it intentionally. And it's always, I'm going to put it back, right? I mean, I'm just borrowing it. And it could start off that way, but it doesn't end up that way, right? Because then he dies. Well, then I want my 1/6 share, don't I? Right? I still do. Because I don't want all the other siblings to get it. And we get nothing because I already took it all. So those kinds of things. And so that's one of the benefits. And it happens. This stuff happens. Trustee influence, incompetent, or the trustor makes changes. My wife has a friend who's, it would be the friend's mother-in-law, so her husband's mom, recently passed away, and just before she passed away, the trust got changed to say from where you was going to 3 kids, it's now going to 1. And it was the one that was living in that area, up here by the way, and the one daughter was helping take care of him, and so, but now, rather than the estate being distributed 3 ways, it's being all given to the one daughter. Right? And the change made within a year of death. By her husband's friend, who's an attorney.
Oh, yeah.
See, even you think it's weird. See? But those are the kinds of things that happen. Right? I mean, if the person was smart, he would have went back to the attorney who drafted it. Because it sounds less suspicious. Right? But I mean, but just stuff like that happens. And so was mom improperly influenced? And according to your moans, yes. Right? Yes. Cases that are handled, like we said, trustee, beneficiary disputes, asset disputes. Asset disputes would be, I'm supposed to get that, or even something where it's not in the trust. Something's not in the trust, or that asset is actually a part of somebody else's probate estate or somebody else's trust. And we have to use the court process in order to get it in. In the investment of assets, in other words, the trustee has a requirement, a duty to invest in assets. So for instance, if my dad becomes incapacitated and I take over as trustee, I can't put all the money in bank accounts. It's got to be invested in a very balanced way, right? To prevent from depreciation. Nobody ever is concerned about appreciation. All right? Nobody's concerned about that. But to prevent from going down in value unreasonably. Right? So and it's not a matter that the stock market doesn't go down, it does. But it's like if I had all the money in a company like Enron, right? And we all know what happened there, well then you lose it all. So it's all got to be balanced. And that's kind of the idea. If it's not balanced, then the trustee's in trouble. Administration or handling the trust issues could be as simple as, hey, I want my sister to live in my dad's house, but the trust doesn't allow that. All right? And so now I'm the trustee, and I say, hey, I can do anything I want. I'm the trustee, I'm going to let my sister live there. Well, the other siblings now can bring an action to say, well, no, the trust doesn't say so. Right? So I can't just do what I want. I'm the trustee. I still have to follow the rules. And one of the rules is what you said in your trust. If I'm doing a bad job as a trustee, well, you should be able to remove me, right? Yeah, you should. I mean, if you're all the beneficiaries and I'm doing a bad job, you'd want to remove me, right? And replace me with somebody else. So, like Rick. Maybe Rick will do a good job. Getting assets into a trust, I alluded to that a little bit. Undue influence. That's kind of, everybody influences everybody, right? I mean, that's just what happens. Everybody has influence on somebody else, especially if you have a relationship. Well, undue influence is something that I would normally have done, except you exerted so much pressure on me that I would do it. So if I had a firearm in my hand and I held it to Daniel's head, and I said, Daniel, give me $100. Right? That might be undue influence, right? But if I stood here and I just said, hey, Daniel, how about you give me $100? He said no, right? There's no consequences to that. Like, for instance, Daniel's living in my house. And Daniel relies on me for everything. Okay? He's relying on me for everything. I said, Daniel, you got to put me on your accounts. You got to put your house in my name. Otherwise, you're going to be living on the street. Think about it. That happens. That's undue influence. Any kind of pressure I put on him, to make him do something he normally wouldn't do is undue influence. Now again, I say, hey, how about you buy, let's go to a Sharks game. You're going to buy it, okay? He's all, I'm all for it. Let's go. I'm no undue influence. I've influenced him, right? But not undue. You could say, he'll say no consequences. What other types of things? Contracts, elder abuse. If Daniel's over 65, now I've got to be worried, right? Because anybody over 65 is considered elder from a standpoint of elder abuse standpoint. So those of you who are over 65, you've got that little trump card there. Personal injury, wrongful death. But if you're unsure, Elaine, who's the litigator in the office, she's got a network of other attorneys that Elaine's done well over a couple thousand, as an example, well over, I know it's several thousand, I think it's more than 2,000, unlawful detainer, right? And real estate, just trying to get people out of houses and stuff like that. And it comes in real handy when you've got a child living with you and that child's not the trustee, and they decide they're just going to live there for the rest of their lives too after you're gone. Getting them out of the house, that's very helpful. Defending legacies, that's it. All right? That's all. I need a drink. Not that kind of drink. David back there said, don't do this. I don't know why. Administration. We're headed into administration now. So that was defending legacies. Now we're in administration. It's a process. You can flip the sideways. It really is. Everything about administration, whether it's trust, whether it's probate, it's all about getting from one point to another. Right? And administration in general is two main parts, and a bunch of different subparts. One is settling the final affairs of the person who died. Okay? Now we're talking about post-life, afterlife. A lot of what we do also deals with incapacity. So somebody becomes incapacitated, and we have to deal with that situation too. All right? Or think about it from this perspective. Even if you're a trustee of someone's trust, they decide they just don't want to be trustee anymore. And that happens, by the way. Right? People are, every once in a while, somebody is in their right mind, and they're realizing their deterioration, and they just say, okay, I'm going to step down, and somebody else needs to take over. Okay? And that from time to time happens, and some of the stuff we're going to talk about, deals with all of those types of situations. So either after somebody's passed away and someone's taken over as a trustee, and that that other person could be a surviving spouse, by the way. So don't exclude yourself if you're a surviving spouse in some of these things. But it's also not just after somebody passes away. So someone is still living, but they just either not going to be the trustee, or they can't manage, or they cannot be the trustee or manage their own affairs, even if there's no trust. This one here basically just goes through a lot of the emotional stuff, a lot of the stuff we just talked about too, and why litigation and everything happens. The aftermath of losing a loved one, the idea there from an administration standpoint is to just basically carry out your intent. That should be the goal. The goal should be carry out the intent of the person who passed away. Not my intent. And my intent is, if I'm the surviving spouse, if I'm the child, this is what they told me. I can care less what they told you, right? So from a standpoint of telling, I can remember having a conversation. My mom and dad had a business, and when growing up, and I forget where I was. I maybe graduated from college, and my mom was asking a question, and I can remember it was tax related. And so I said to my mother, I said, Mom, well, you're going to go see the accountant. When you go see the accountant, the CPA, ask them this question in order to get your answer, right? So she goes to the accountant, asks the question. The accountant answers. My mom comes back, gives me an answer that's like way over there. I mean, it's like, how did that become the answer? Well, it's because when I asked it, I asked a very specific question. My mother then did what? She interpreted it to her understanding. And then she took her understanding and said that, right, to the CPA, who interpreted it to their understanding, gave it back to my mother, who interpreted her answer to her understanding, and then gave it back to me. Right? So it's like, so what started out as here ended up way over here. You know, and it's like, wait a minute, that just doesn't add up. And so, you know, that's kind of the idea sometimes with saying things, right? Saying things. Sometimes people say things, and none of you do it, but they do it just to get the person off their back. Like I've had situations where somebody passed away and the kids would say, well, you know, I was supposed to be the beneficiary of that life insurance policy. Yeah, but they didn't do that. Right? They didn't do that. Why? They just wanted you off their back. And sometimes as a kid, sometimes as a spouse. I've seen that too. Right? They'll constantly say this to the spouse. Yeah, I took care of that. That's taken care of. You know, and the spouse comes in and says, well, they were supposed to do this, and they said they came and saw you to do this. Well, they didn't do that. But they said they were going to do it. Well, it's not what they said, it's what they do. And so that's what we have to deal with, right? We're dealing with what you've done, what you've put down on paper, what you've signed, what you've written, what you've signed. So more than anything else, I don't think, for me, what I do is very complex. This says legal complexities and stuff like that. I don't believe it's complex. But this is the way I look at administration. I can perform most basic tasks. So when it comes to plumbing issues in my household, right? My wife will say, well, we need a garbage disposal replaced. And I say, okay, call the plumber. Why? Is it because I can't replace it? No, I can't. It's going to take the plumber how long to replace that garbage disposal? 10 minutes, an hour, something like that, right? And then you have it on the truck. And it's going to cost a little bit of money, right? But it's going to be done in an hour or whatever. If I'm going to do it, how long is it going to take me? Probably 2 days. All right? I'm going to be down at the hardware store about 5 times, getting the right part, getting the right fitting. I'm going to be grumpy. I'm going to yell at the dog, kick the cat. And my wife's going to tell me several times, you're grumpy. And I'm going to say back, no, I'm not. Right? But there are also some tasks that I may not know how to perform. And then I'm going to over-research the thing. Right? I'm going to be down there for 3 or 4 days trying to figure out how to do it. Right? So this task, right, that I think is pretty straightforward. And maybe it's because I've been doing it for 30 years. But this task that I think is straightforward, you know, it takes some time for you to figure out how to do it. So sometimes it's just easier to say, we'll go ahead and do it. All right? Because it should be done in a more efficient manner. So planning ahead can alleviate some of the frustration. See, one of the things that I think we all tend to forget is that if I'm going to put something in writing, I believe everybody's going to just follow it. But we're dealing with human beings, right? Who are filled with all kinds of emotions and everything else. So know the process. And this is your family after you pass away. This is your family, all right? So they're going to fight because they fought when they were kids. And as someone in the office, I think is fond of saying, you know, the toys just get more expensive. They fought over toys when they were children. They're going to fight over toys when you pass away. The toys are just a little bit more expensive. It's a process, and it takes some time. A trust administration can take anywhere from, like, say, 12 months or something like that, give plus or minus a couple of months. Probate could take 2 to 3 years. And it's not because the process in a probate is longer. It's basically the same stuff. You're basically doing the same activities in a trust, in administration of a trust or administration through court. It's just now you're subject to the court's calendar, right? And so if somebody with an administration starts and gets us right, somebody passes away, let's say, and somebody's taken over as trustee, they come into the office, they have a death certificate, we get them started right away. It may be 4 months before the executor gets started. Because it may take 4 to 5 months just to get a court hearing. To have a hearing to determine whether the person named in the will is going to serve as the executor. So it's just a matter of timing on the court's process. But the actions are primarily the same. There's a few differences and stuff like that. So the next slide, and I went over this next slide 2 years ago. Now I'm going to go over it in about 2 or 3 years from now. But it's the basic things that need, legal actions that need to be taken in order to carry out the estate. There's land records, there's notifications to beneficiaries, to counties, to IRS, to Franchise Tax Board, Department of Healthcare Services is lodging a will, getting a tax ID number, and a notification of the IRS. So those are things that, like I said, I discussed a couple of years ago. And I'll discuss it again in a couple of more years. So if you weren't here a couple of years on, hang on. We'll be there in a little bit. Yes, ma'am?
Is that something you would talk about in the updating the records?
Updating
your trust, I mean? Are these some of the things you talk about?
No. Yes, if there were some of the things in updating the trust, then no. Because these are all administrative. These are, like, as an example, I'll take the first one. Update land records. So somebody owns a piece of real estate. Their name is on the real estate, right? And they pass away. And let's say there's a trust, right? Let's say there's a trust. But whose name, while the person is living, whose name is on the deed? The person, right? So if it's Daniel, right? If Daniel's got a trust and he's got a piece of real estate, it's in the trust, it's in Daniel's name as trustee of Daniel's trust, right? Daniel passes away. I'm the trustee. Update the land records? Well, if I'm the trustee, I got to get my name on that piece of real property. Not as the owner, but as trustee. Because if I want to sell it, and Daniel's name is on the deed, who are they going to be expecting to sign that deed transferring it? Daniel. And he can't sign. Right? So I got to update the land records so Daniel becomes incapacitated. All right? And so now my obligation as a trustee is to remove his name because he can't be trustee anymore. He's not. So I remove his name as a trustee and put my name on. That's kind of an example. It's a legal requirement. It's a legal requirement. This next slide shows all of the duties. David. There you go. Thank you. All of the duties, or a lot of the duties of the trustees. The trustee, I'll say a little bit about a couple of these things. The trustee is a fiduciary. Think of it as a banker. They're in charge of someone else's money. Right? A banker is in charge of something. The banker has all kinds of money in their possession, but it's someone else's. It's not all theirs. And so they're held to a fairly high standard of care. And so when I'm representing a trustee, I tell that trustee, look, even if your name is listed on that trust as a beneficiary, don't consider it yours. It's not yours. You're always a trustee. Always a trustee. You're a trustee first. You're not the beneficiary. Because if you start thinking of it as yourself as a beneficiary, then when you start to say, well, you know what, I could use $1,000 right now, I'll just take it. Right? I'm a beneficiary. I'll just take it. Well, no, right? Because there's about 10 of those things, or 5 of those at least, that you just violated when you did that. And so it's like, never think of it as your money. It's always someone else's money. And I'm put in charge of investing and protecting somebody else's money. So, so that's kind of what this trustee's duties is. There's a couple of them in here that I think I'll mention, just in passing. There's a duty to deal impartially. Remember the sibling thing? Well, sometimes siblings have favorite brothers and sisters.
Yes, sir.
Impartially means no favoritism. Everybody has to be treated equally? Question? Equally? No. They have to be treated in a like manner. Because they may not be equal beneficiaries. Right? In my trust, right, Michael might be a 20% and Rick may be a 30%. Right? So, in a like manner. There's a duty to account and keep beneficiaries informed. If I'm a trustee and all of you are beneficiaries of this trust, let's say we go and say my dad's the decedent, and you're all at his funeral. We see you there. Condolences to me. My dad passed away. And I see you all there, and I thank you for coming and everything else. And maybe every single one of you asks, are we going to hear from you? Because James, we know you're the trustee. We're going to hear from you soon. Yeah, you'll hear from me soon. A week goes by, you haven't heard anything. A month goes by, you haven't heard anything. 3 months go by, you haven't heard anything. I buy a new car. 4 months go by, and when you start getting nervous? Right? Yeah, you've already been nervous. Huh? So, just because I'm the trustee, right? No, but I mean, I've got a duty to keep you informed. Because if you don't hear from me, you're going to think everything is fantastic, right? You're not going to think bad things. No, because that's not our nature. Our nature is not to think the worst, right? It's to think the best. James, he's looking out for our best interest. Yeah, he'll get to us, right? Yeah, no, yeah. No, we don't think that way. We just don't think that way. So I have to, the law says, I have to be proactive in informing you. You shouldn't have to be asking me what's going on. I should be telling you before you want to ask what's going on. Right? And I have a duty to put that in writing. I have an obligation, according to the law, to put all of the financial records in writing and present them to you at least annually. Because at the end, right, my dad passes away, and at the end, I hand everybody a check. Here's your check, here's your check, here's your check. And I haven't given you any information. You trust me, right? Right? I'm going to, you trust me? Yeah. I mean, this is James. This is Morris's son. Right? No. I got to show you what I did with all the money. I got to show you what I started with. I got to show you the bills I paid. I got to show you the income that came in. And I have to do it proactively. Right? It's not an option. It's a requirement. And if I don't do it, you can hire Elaine and she can try to remove me as a trustee. See how that works? Lousy Elaine. What a kid, Elaine. I like it. And I love this one, so I'm going to bring it up anytime I can. Co-trustees, I hate them. Can't stand them. Can't stand it once ever. You know why? That means I have more than one boss. Right? I mean, what is it? A divided mind? You know? Yeah, I have more than one boss. I have more than one person telling me what to do. And not only that, they have to agree. They all don't have to do, but they all have to agree on what's done. Right? So if I have co-trustees, well, they don't both have to sign a check, but they both have to agree the check has to be written. Right? So, I do like my example. Co-trustees, there's a car. I've got a co-trustee car. Right? And there's let's say there's 4 trustees. Well, this car has 4 steering wheels, 4 brake pedals, 4 accelerators, 4 gear shifts. We're going to go from here to the prune yard. How long is it going to take us to get out of the parking lot? That's co-trustees. Because either they all have to work in unison, or 3 of them have to throw up their hands and say, okay, you do it. And not only that, sometimes I've had clients say, yeah, but if I don't put that one down, I'm going to make them feel bad. Or if I don't add them, they're going to feel bad. Well, think about the one you're burdening with, right? That one, and putting them on as a co-trustee. The one who's going to do all the work anyway. Right? Having that, it's kind of like an anchor. Having that anchor there, is just going to muck up the whole process. So, is it more efficient to have a committee of 1 or a committee of 4? Right? If the one has to follow your instructions, and the one has to follow the law, right? Is it easier to have a committee of 1 or a committee of 4? 1. Right? 1. That's all I'm going to say about that. Anybody want a box of chocolates? Okay. Tax returns. This is where I'm really headed for today. Oh, look at we're out of time. No, I'm only kidding. So, in an administration, whether it's trust, probate, and think about it, even in capacity, there's still tax issues, right? So, somebody passes away. Let's say they pass away on May 31st. May 31st, somebody passes away. Any income taxes that they have to file for that year, the year of their death? Absolutely. From January 1 through May 31st, they've earned some kind of income. And even if you say, the trustee comes to me and says, well, they haven't filed tax returns in 10 years. I don't care. File the final one. Because guess what happens on the final one? Social Security number and deceased gets put on the top of that final one. So now the IRS knows that Social Security number is now never going to generate more income after May 31st. One of the legal requirements that we skipped, but is to get a tax identification number for the trust or the estate. Why? Because the decedent's tax ID number, Social Security number, is no longer valid. So the trust becomes, or the estate becomes, a separate taxpayer. So when does that entity start filing tax returns? June 1. Their tax year starts June 1, right? They start earning income June 1. And when do they have to file a return? Well, within a year. Either calendar or fiscal, right? Calendar meaning the year ends December 31. Fiscal means you get to elect, you get to choose when they end. So if somebody dies May 31st, you can pick the end of April as the last day of that year for the trust or the estate. Right? You don't have to, but you can. Or you can pick any other day within there. So tax returns still need to be prepared and filed for the person and for the trust or the estate. Estate tax returns. I think Victoria kind of hammered a little bit on that. There's a $13,610,000 credit and stuff like that. They got to be filed. Maybe, right? Surviving spouse, portability. Is that up there? No. Yeah, it is. Surviving spouse, portability. Well, that can be helpful, right? She mentioned the estate tax credit's going down somewhere around $6 million in 2025. So, yeah. Here's the thing I think about portability and estate taxes for surviving spouses. There's several factors. It's not just a dollars factor initially. Does anybody believe here that assets like stocks and real estate double every 10 years? No. You don't believe that? Does it go more than double or less than double? Okay, so I don't live in this area, but I live in an area that's in California. So I bought a house, my wife and I bought a house in the year 2000, December 2000, so 2001. We paid $320,000 for that house. Sure enough, in 10 years later, it was about $700,000. And 10 years later, which is now, it's about 1.4. If you don't believe it, go back and look at your numbers. Your estate doubles. If you're not consuming principal, it doubles at least every 10 years or sooner. So if someone's 50 and their spouse passed away, the survivor's 50, and they've got a $3 million estate, start doing the math. If you're not consuming principal, start doubling that every 10 years. Does that spouse need to make a portability election? They may. They may. So portability, estate taxes, needs to be thought out. Income tax basis. If I buy something for $100 and I sell it for $300, do I have to pay taxes on that $200? Well, I'm supposed to. Right? I'm supposed to. And if they can't catch me, you got that, YouTube? You know, if they can't catch me, no. But yeah, you're supposed to pay taxes on it. But on the other hand, if I buy something for $100 and I die and it's worth $300, and my family sells it for $300, there is no tax. Because it's the new basis issue, right? It's what they call step up. But it doesn't only step up, it also steps down. Which means that if I bought something for $300 and I died and it's worth $100, the basis is now $100. And so if the family waits for it to go back up to $300 before they sell it, then they're going to have to pay capital gains on that $200 increase. Because the basis is at $100. So it goes both ways. Property tax, no exemption in California as far as I'm concerned. Time matters. I guess he brought that up because he says, "Hey, James, I can hear the song from the Academy Awards coming on, right? Amen. That it's time to move on." Yeah. So, trust administration available. There's nothing. Yeah. Basically, it's just the stuff they got to do. Start gathering stuff together. Locating everything and coming into the office. It's a process. We want to avoid the control of the court, and that's why you did a trust. Yeah, by the way, from the whole standpoint of the trust, what you're really looking for is eliminating the family from the court process. That's the primary goal. Right? There are other goals, there are secondary goals and stuff like that, but that's the primary goal there. Blah, 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 fees. Yeah, we like getting paid, so deal with it. Trust administration and the process. Who should I refer? Everybody. Everybody. Friends, family, countrymen. Your enemies. We'll represent them too. We don't discriminate. We'll take anybody's money. Come on. This is good stuff. I've worked on this for years. So, everyone, and why? Right? Why? Okay, why us? I look at it this way, and hopefully you guys don't get tired of this, but those of you who know me know that I'm not very emotional and stuff. But I'd never know why somebody's coming in. I look at everybody on that other side of the table from me as being appointed to be there by God because I believe God is sovereign over all things. Okay? All things. And so I had this gentleman come into my office whose son, who was in his 30s, passed away in a motorcycle accident. And he was wondering, what do I need to do? All of the different, general questions as far as administration. And I helped him out as best I can. Gave him some guidance, provided him some direction. And the thing is, we sat there and we chatted, I don't know, for an hour and a half. And anybody who knows me knows that there's really, there are serious conversations, but I'm usually bringing in levity and laughter because I think that's all important in life. And at the end of the meeting, he shook my hand. Actually, we stood, shook my hand, and hugged. And he said to me, James, I haven't laughed in 4 months. Who's to say that's not the reason he came in? The only reason he came in is that. I don't know. So sometimes it's not even to be a client. With that, I see that our hostess is walking up to take the mic away from me. And so I will thank you for your time and attention and bid you adieu.
All right, so we are at the end of the seminar for today. If you have made an appointment, oh James, I have your age glasses. Your age is showing.
This time I took my watch, that's my glasses.
So if you have made an appointment, if you have not made an appointment but plan to, one of the things that we ask you to bring is, if you have a trust prepared by a different attorney, we would like to review that. We have also, or will send you a questionnaire before that appointment. Now, for those of you who are clients, we still ask you to go through it, and especially if things have changed, fill it out. Some of the information is redundant, but I cannot tell you how many times I've seen two scenarios. One, they've moved 5 or 6 times since they updated their address, so I don't know who we've been sending the mailings to. The second thing is, I had one where they had identified 1 child in their trust, and by the time they came back, they had 5. So, if things have changed, please let us know, because otherwise we have no clue. And then, of course, any questions that you have for us. But we are here for you guys. One of the things we also ask is that you fill out those green sheets to let us know how we did, because again, we want this information to be helpful for you. So if there was something that you wanted more on, less on, you just have an opinion of something, please do let us know, because we take that very seriously. If you want a note on there also that you need us to follow up with you, you weren't quite ready to sign up today, or those times didn't work, there's a spot for you to check and let us know how to best get in touch with you. With that, I hope you guys have a great rest of the weekend. If you're an Easter celebrator, happy early Easter, and we look forward to working with each of you. Thank you all. Yeah.